Good morning, everyone.
Morning, sir.
Good
Hope
morning,
you all
sir.
hear me and see me. The time is now 9:30 and the inquiry is resumed. This inquiry relates to the appeal made against the decision of Charnwood Borough Council to refuse an application for up to 170 dwellings at land to the east of Cossington Road in Sileby. This is day 5 of the inquiry, and a few housekeeping matters as always, please. Ensure your mobile phones and other devices are switched to silence if not in use for this event. Unless you're speaking, please switch off your microphone and video. And there will be 2 sessions before lunch and 1 session after lunch today. We'll aim to break about 11 o'clock for 30 minutes and then breaking for lunch at 1 o'clock for around an hour. Just to bring everyone, remind everyone where we've got to with this inquiry. We've heard from interested parties on the first day and had question and answer discussions with some of the appellant's technical witnesses on the first day too. On day 2, we held roundtable discussions on education matters as well as conditions and planning obligations. Day 3, we heard from the council's landscape witness, and on day 4, we heard from the appellant's landscape witness. I've also carried out my site visit to Sileby and the surrounding area, which took place between day 3 and 4, if I can get my days correct. So today the intention is we'll hear the evidence of the council's planning witness, Mr. Gould, and then if time allows, we'll start to hear the evidence of the appellant's planning witness, Ms. Smedley. Before we get going, obviously probably worth bringing ourselves up to date with documents and other procedural matters. First of all, are there any interested parties who wish to speak who haven't already indicated that they wish to do so? If so, the hand's raised. I can see there's a hand raised by Ms. Shuttlewood.
Yes, thank you very much. My name's Sarah Shuttlewood. I'm representing Leicestershire and Rutland Clinical Commissioning Group, so a health representative. I'm here to assist the inspector in the case if needed. I certainly don't want to extend the inquiry, but if there's any information, clarification from a health perspective that you would like, I'm very happy to support that. If I'm not here and you need my contact details and you need to call me back in, then I can put my details in the chat, because obviously from a health perspective, it would be really clear. I've got the CCG's legal representative here as well. I just also wanted to make clear from a conflicts of interest perspective, the appeal is by David Wilson Holmes, East Midlands, and Anthony Raymond Shuttlewood, and we are not related, as far as I know.
Fine. Okay. I hadn't even picked that up. But thank you very much for that. Thank you. And so you're the legal representative. Is that Leanne Marie and Anna Collier? Sorry, I mangled that.
Yes, that is exactly right. Correct. Thank you.
Thank you. I can see her on the screen. Thank you. We'll come to the issue of healthcare in a moment, but thank you for introducing yourself. Anybody else who wishes to speak who hasn't already done so or indicated? Okay. Thank you. We'll then just run through the documents that have been submitted since we adjourned a few weeks ago. So I've had the Leicestershire Round Handbook, the walking route that's gone on as document ID 14. I've also received an updated list of conditions, which I think has gone on the website as inquiry document 15. And I don't think there's anything arising from that unless parties want to tell me otherwise. Anything from either shake of head from Mr. Tucker, Mr. Richards?
No, sir. So far as we're concerned, we think that is the finally agreed position between us. Okay.
I certainly had a look through it. I can't see anything that sort of jumps out at me as needing to be discussed. So I think we can leave that there. So thank you. Thank you to both parties for finalising that. Then as we've just heard from Ms. Shuttlewood, it's worth mentioning the next couple of documents that I've had in the interim, which was the response from the clinical commissioning group to the appellant's proof regarding healthcare contributions. So I've received and accepted that as inquiry document 16. And then I've had the response from the appellant to that response of the CCG, which I think I've asked to be added as ID 17. I think ID 17 appears to be on the website. ID 16 doesn't at the moment, but I'm sure that can be sorted, Mr. Richards.
Yes, I've noticed that, and those responsible will have heard your remark.
Yes, okay, thank you. In terms of the response, is there anything arising, anything that anybody wants to say about both the CCG's response and the appellant's response? Anything the council, Mr. Richards, you want to say?
No, sir. You've seen from our SIL compliance statement the position we take. Mm-hmm. There is a lively ongoing dialogue between the two principal parties, the CCG and the appellant. Mm-hmm. We don't think it will assist you if that becomes a tripartite discussion, and therefore we've resisted from weighing in on that issue.
Okay.
We think that now you're the decision taker, you've got all the information you need to reach a view one way or the other, and we don't think we can usefully add anything to the totality of your knowledge.
Okay. Thank you, Mr. Richards. Mr. Tucker, I think your hand was raised next. Do you want to say anything about this matter?
Yes, sir. Simply to say this, that we concur with what Mr. Richards has said in terms of you now have all the information. We take the same view. You made the observation, sir, through the programme officer that you didn't wish to hear anything further. And really, just as a matter of process, it's not my intention to lead any evidence from my witness in this regard. We're happy to leave what we say in writing. So we don't need to call live evidence, nor do we think a discussion is needed. And so on that basis, despite the fact in Ms. Smedley's proof you have a discussion about that, I'm not proposing to lead evidence about that, nor do I apprehend it will be cross-examined.
Okay. Thank you, Mr. Tucker. And Ms. Shuttlewood.
So the point I would like to make is, in terms of the appellant's response to our response, there are some points of detail and clarification that, if you felt would be helpful, we would be happy to give around GP practice registration being open or not, and the fact that the infrastructure funding is exactly that, infrastructure funding. It's not about double payment for primary care services.
Okay. Yes, I've already indicated that I wasn't anticipating the need for further discussion. If there is something factually, a factual issue, I don't know if Mr. Tuck has a view on whether that should be, is there something that should be allowed or not. I mean, I obviously want to make sure I have the right information. I don't want to have a lengthy debate about any of this, because I agree that I have the information, I have the two sides' positions, and I can see that there's probably there's going to be little sort of meeting in the middle necessarily. But if there's any sort of factual issues, then that might be worth raising. Mr. Tucker.
So I have no difficulty if there are any factual corrections, and I do mean factual corrections, that the CCG wishes to put forward. But so it's probably best that those are put to us outside of the inquiry, so that we can agree that those are factual matters. So, for example, Ms. Shuttlewood made 2 points there, one of which relates to GP registration lists and whether factually they are closed or open. I'm entirely comfortable about having the correct position one way or the other in that regard. The second point is that she made related to whether infrastructure relates to infrastructure, the interface between that and what's properly recoverable under section 106. That goes beyond factual matters, and that really deals with the substance of the dispute between the parties. So I've absolutely no difficulty in true factual points being made in order to correct that, so you've got the correct information. But so that has to go through the filter of making sure that that's really factual and not an opportunity to provide a further response, given the history of this matter. And obviously, sir, we would like the right of final reply. So if there remains a dispute on what's said, then we need to respond to that, as we already thought we had done. But subject to that, if that can be done during the course of the morning, because I don't anticipate that there would be anything in of great detail that needs to be said dealing with the actual facts, then great. And then hopefully we can report back to you. But in terms of a further discussion, so we don't think that's necessary. And so a game of forensic tennis, I don't think is necessary.
Okay, thank you, Mr. Tucker. Ms. Shuttlewood, any response to that?
Yeah, we're happy that we have that conversation outside of the actual hearing itself, and then we can come back and confirm whether there is factual discrepancy. Okay,
thank you. In terms of the logistics of that, Mr. Tucker, is Mr. Hunter available today, or I think you said he might be available tomorrow?
Well, if the points can be emailed to us, then we can perhaps have that engagement, because I suspect Mr. Hunter will be able to answer his emails even if he's not able to come to the inquiry.
Yes.
So the sooner we get that information, the better, and then we can hopefully engage with that. So I suspect not today, but we may be able to respond to that by electronic means anyway.
Okay. So, Ms. Shuttlewood, are you able to email then do you have the appellant's details to email?
I'm sure we have. Yes, thank you.
I'm sure you probably have. Yes, be one of the various people, and yes, and if that can be done, I think so. Would it be possible to have an update by tomorrow morning as to where that's got to, if from both the appellant and the CCG's perspective?
By all means, sir, if not by the end of the day.
Yeah. Okay. Ms. Shuttlewood, anything else you want to say on this matter at the moment? Okay.
No, thank you.
Okay, thank you very much. Well, I'll leave that with the appellant and the CCG then to have that discussion outside of the inquiry, and then please update me in due course. Thank you. Then the only other document that's come to me during the interim, as far as I'm aware, is the engrossed version of the Section 106 agreement. So the final draft agreed between the parties. I've had a flick through that document, which I'm going to say if we can have that as inquiry document 18, please. The key changes, as I can see, are the relate principally to the outdoor sports elements. So if I get this wrong, please let me know. But I think the allotment contributions now say it's linked to a community growth space for additional allotment plots at Sileby Park Memorial. So Sileby Memorial Park, even get my word in order. The indoor sport contribution has been deleted. The outdoor sports facilities contribution has been clarified and linked to football and/or cricket and/or bowls within that Sileby Memorial Park. The early years contribution has been clarified that it would be towards the provision of early years places at Cossington Primary School or other schools with such early year provision in the local area. So I think those are the principal changes. I didn't get a track changes version, but I don't think I need one. I think I managed to sort of have the two versions open and flip between the two. Have I got that right? Are those the main changes?
So you'll be pleased to know that the message I've just received from the WhatsApp group is the inspector has it correct. Okay. So that my instructions are clear that your understanding is correct. So apologies that wasn't spelt out in a track changes version.
That's okay. I think it's helpful. It was helpful for me to go through it, to sort of check carefully anyway. So,
there is one other point in relation to that. My understanding is that that is now agreed with the county council insofar as it relates to them. So I don't know if that's been confirmed by the county council, but if not, we'll make sure that that's confirmed in writing to you as soon as possible.
Okay, and so, yes, so that they're content with everything that relates to their sort of purview.
Precisely.
Notwithstanding, obviously, the disagreement on the principles, but yes, in terms of the content. Okay, thank you. Anything else, Mr. Richards? Anything else you want to say about the 106? I'm not sure I've had a copy of the projects, the outdoor sports and allotment projects that I think was suggested was going to be provided before Easter, but I don't know if that's still out there, Mr. Richards.
So the answer to that is I don't know, but I'll check. Okay. So far as the 106 is concerned, we are now content that is the final document, and we have no further comments to make on it. There is an internal council process for signing off 106s, which involves not simply the signatory being satisfied with it, but getting input from a number of senior officers around the council, and for that all to be confirmed in a written report. My advice is that process will be completed this week, and then therefore the document will be signed next week.
Okay, and is that presumably just the borough council you speak for, not the county council?
Yes.
Do we know how the county council their process for signing any?
That I don't know.
Okay. I mean, I was going to obviously discuss the deadline for receiving the executed version. I'm content to allow a couple of weeks from now for that to be completed, if that sounds reasonable to the people who obviously have to sign it. It sounds like the borough council should be okay, but the county council we would need to check. Mr. Richards.
Yes, that's correct. And I'm quite sure that somebody from my team will be able to make contact with the county council because I don't think there's anybody at the meeting today.
That's okay. Well, we're not finishing today, so if there's a need to alter that because of the county council, then we can discuss if that's practical.
Yeah.
Thank you. And Mr. Tucker, in terms of the appellant signing, there's a sort of 2-week deadline. Seem okay to you?
I think a 2-day deadline suits us. I'm told that there is only one signatory required, and that's from the DWH perspective, and that's going to be done within the next 24 hours. So
Right.
it's really a matter for the authority in terms of that timescale, and 2 weeks sounds generous, frankly.
Okay. Well, so you say presumably it's already been signed by one of the appellants. Yeah.
That's right. So yes.
Okay. Well, fine. Well, it sounds like the Borough Council can turn things around within a week or thereabouts. We'll, if somebody from the Borough Council can check with the County Council as to their sort of timescales, and then later today or the next couple of days, if we agree a final date to receive it, then we'll work to that.
And we'll chase the county council as well. So because obviously we're the ones that have been told that it's agreed by the county council. So we'll chase it and hopefully report back by the end of the day as well on that.
Okay. Thank you. Anything else from anybody on the section 106? Okay. Yes. So that could be added to the website as an ID18. Then it's there for everyone to see. Thank you. That as in the version that I have. I don't necessarily require the signed version to go up on the website, but certainly that version. Then thank you. I think that's all the documents and other matters that have arisen during the interim. I have a list of documents for Mr. Gould's evidence in chief. So thank you for that. And obviously, if there's anything else that we need to refer to, I'm sure both advocates will let me know. Is there anything else? Any other procedural matters or documents, Mr. Richards? Anything from the council?
Yes, sir. A couple of things. Firstly, just to confirm to you, which I should have done earlier, that the YouTube stream is live.
Okay. But
I'm told that they can see everybody except you. They can hear you.
Well, at least they can hear me. I'm not sure seeing these. Important, but...
Now, if we want to rectify that, we would have to stop the stream, we think, and restart the laptop.
Right. Okay.
I.e. the usual Control-Alt-Delete response to a technical problem.
Okay.
We'll try that during the break, unless you think it's so urgent that we should try it now, but it will mean I think we would have to pause.
Okay. I think we can leave it till the break. I mean, the next session is going to be largely between the barrister and the witness. So yeah. I don't think seeing me is going to be that critical. So I think we can wait for the break for that. Thank you.
Yeah. Then the second thing is that I alerted the inquiry when we were last sitting that the council was about to publish an update to its 5-year housing land supply position.
Okay. Yes.
I'm told that it will not be published until Friday.
Okay.
However, I can tell you that we do not expect it to be materially different to the 3.34 years supply that we are currently working with. You've got it to 2 decimal points. My best intelligence is that there may not be even a change to the last decimal point.
Right. No change at all then, potentially.
Well, yeah.
Okay.
But anyway, I've been told, and this is probably good enough for us, that it is not likely to be materially different, if at all.
So I think we said before Easter that if there was anything the appellant needed to know in advance about being published, that might be something the council could provide. But I don't know, Mr. Tucker, presumably the appellant hasn't seen anything. But
no, we haven't, sir, and that's the point I was going to chase behind the scenes in any event by my learned friend. Once you get that sort of exercise down to 2 decimal places, you're adding a spurious degree of accuracy anyway. So yeah. It's 3.3 and it's not going to change. The only issue is the base date is going to be updated to a year further along the line, and the authority still has no 5-year housing land supply, which is the point that I'm making closing.
Yeah.
So that causes no difficulty to us at all. Obviously, if we could see a draft before it's published, so before I deliver a closing submission, just in case there's anything in there that my clients would shout at me if I hadn't read it and picked it up, then that would be splendid. Failing which, so we just have to maybe take 15 minutes on Friday.
Yeah, I mean, if it's any reassurance, I haven't even seen a draft yet because it's being held so close to the chest of those who are producing it.
Okay,
but that's the position.
Do we know when on Friday they might receive something?
I don't, but I'll let you know after lunch.
Okay, because obviously we'll hopefully be hearing closings in the morning on Friday. So
yes.
Depends what time.
And it may be, sir, if it's not before lunch, then the answer may be that we work in a time schedule so that we would have comments within the 2 weeks anyway, and the comments may very well be that there is no comment to make about the content, but the document's produced to you anyway.
Yes, well, for completeness and clarity, if that document is provided, and then obviously yes, comments can be invited if any are needed.
Yeah.
Yes, sir.
Okay.
And then next, Humble Lane.
Oh yes.
Has been back to committee.
Right. I think that was due to go back, wasn't it? I think yes.
Yeah. And the outcome of that is that the committee has maintained its resolution to grant. There have been some tweaks to the conditions, that the wording of the conditions that the members wanted to make. And there's been a tweak to the section 106 requirements. But the otherwise, the position has been maintained even after considering it was the landscape issue, you'll recall, that was discussed. That was reported back to the committee, and the committee has maintained its view.
Okay, so in regards to this appeal, have there been any material changes?
No.
No. Okay, thank you. Mr. Tucker, anything you want to say on that?
No, sir, and I don't think you need to be troubled with further documentation with regard to that. There was a little hiccup behind the scenes where it was reported back to the members that there was an agreement that that there was an area of valued landscape. That was corrected by a supplement to members. So obviously the disagreement between the parties, on the one hand, our case that none of this is valued landscape, on the other hand, the council's case that this is immediately adjacent to and overlaps in the northern part of Humble Lane with valued landscape, was reported to members, and nonetheless members took the view that consent should still be granted. It's still a resolution to grant, not a decision, so there's no decision notice. So I don't think you, sir, need to be troubled with additional documentation unless you've got a burning desire to see that exchange.
No, I think from what I've heard from both parties this morning, I think that's fine. I'm happy just to have that update orally.
And then just lastly, sir, and for my own peace of mind and timetabling, you've indicated that we are indeed going to close on Friday, and that whatever advance of the programme we make today, which I support, if we can get Miss Smedley in chief, that will be fantastic. We will not be closing until Friday, is what I understand you have indicated.
That's fine. I mean, I think because we're not going to finish with Ms. Smedley's evidence until sometime tomorrow, I don't think rushing straight into closing submissions is particularly helpful. So, yes, I'm happy to come back Friday morning.
I thought that was the position, but I thought, well, I'll just raise it now just in case. Yep,
that's fine. No, you understand correctly.
Good. And I think that is the end of my list of housekeeping points.
That's fine. It has been quite a long break between the sitting days. So thank you, Mr. Richards. Mr. Tucker, anything else from the appellant?
No, sir. Safe to report that all those that have fallen ill during the course of the inquiry are all now well again. You'll be pleased to hear.
Okay, that was good to know. I think, yes, unfortunately, from what I'm hearing, there's still plenty of cases out there and inquiries being affected by COVID. So it's by no means gone away, but I'm glad to hear that everyone is well. So thank you.
Yes, sir. And I think with the benefit of hindsight, we made the right decision for this to be a virtual inquiry, despite not knowing any of that.
No, well, yes, here we go. So thankfully, we've managed to, well, fingers crossed that remains the case for the next few days.
Yes, sir. Thank you.
Well. Anything else from anybody else? Any other interested party have any points they want to make before we move on? Okay, if there isn't anything else, then if we are happy to move on to hear from the council's planning witness, Mr. Gould, and I think I can see Mr. Gould on screen. Hello, Mr. Gould.
Good morning, sir.
Hello. So, as I say, obviously, I have the list of documents that have been given to me by email in terms of the document references. So, Mr. Richards, when you're ready, please begin with your introduction.
Yes, sir. Thank you very much. And just to introduce Mr. Gould to the inquiry, Mr. Gould, you're Nigel Gould, and you're a director of planning, or you are the director of planning at Heaton Planning Limited, which is a planning, environment and design consultancy comprising a team of planners, landscape architects and ecologists. Is that right?
That's correct. If I could just jump in, just to clarify, WhatsApp is all switched off. I'm in a little room on my own, and I'm not going to be speaking to anybody in the office all day today. But yes, that's correct.
Good. Thank you for that. Yeah. And you're a chartered town planner with over 20 years of professional experience working for local planning authorities, waste operators and private consultancies.
That's correct.
And you provide a range of planning services for sites and clients across the UK, including the submission of planning applications, environmental statements, managing infrastructure projects and representing local authorities and appellants at appeal.
Yes.
And you've got a BSc degree in geography and geology and a postgraduate diploma in urban and regional planning. Is that all right?
That's
correct? Yeah, good. And your proof of evidence of paragraph 1.4 confirms that the evidence which you've provided for this appeal is true and is given in accordance with the guidance of your professional institution. You confirm that the opinions given are your true and professional opinions.
Absolutely. And that, yes.
And you understand that duty extends to the evidence you give now to the inspector at the inquiry?
Yes, correct.
Good. So I'm not proposing that we should read anything, but rather to take the time that I've indicated to you in our time estimates, just to examine what are emerging as the important points as we see it for the inquiry. Is that an acceptable approach?
Yes, that's fine. Thank you.
Good. Yes. So, Mr. Gould, in exercising your planning judgment as a planning witness, I think you're relying on Mr. Higson's expertise in landscape character and visual impact matters to input into your planning judgment. Is that right?
Yes, that's absolutely correct, sir.
Yeah, and therefore we won't be revisiting any of that evidence. That's already been ventilated before the inspector.
Yes, that's my understanding. Yeah.
But matters which are within your purview, and if you could have to hand the planning statement of common ground, please. Core document 10.3.
Yes.
We can see in chapter 3, beginning on page 8, that the development plan position is all set out and agreed.
Correct.
What comprises the development plan? The local plan from 2004, the core strategy 2011 to 2028, and the Sileby neighbourhood plan made in January 2020.
Agreed, yes.
And then at section 4, are set out the matters which are agreed between the parties. And looking first at the section on adopted planning policy in paragraphs 37 to 41, and at paragraph 41, it's agreed that the council is unable to demonstrate the minimum 5-year housing land supply. Instead, 3.34 year supply. And then at paragraph 42, the common ground, it's agreed that the tilted balance in paragraph 11 is engaged and should be applied by our inspector. Just to confirm for the inspector's assistance, because sometimes it changes, was the tilted balance accepted to be engaged when this matter was considered by the local or planning authority?
Yes. Yeah, this was acknowledged at the time of the refusal. It's core document 5.02 in the officer's report, and I concur with both of your statements. So, to my mind, the tilted balance changes the thought exercise the decision maker takes and what they must go through when deciding whether to give consent or not. If it's engaged, it should increase the prospect of securing planning permission. It does not, however, guarantee planning permission, nor does the tilted balance replace the legal responsibility of the decision maker to take account of the local plan. So the tilted balance is, of course, an important consideration. The decision taker is required to take into account all material considerations, and as such can, with appropriate reasoning, refuse an application notwithstanding the tilted balance being engaged. And I would say that was what sits in the reasons for refusal and the officer's report, the background to that.
Yeah, and then just for your notes, so we don't need to turn it up, but in the officer's report, the tilted balance is dealt with the 35th page of the PDF electronic file at the end of the 3rd paragraph.
Correct.
So with that in mind, can we just look at the Sileby neighbourhood development plan for a moment, which is core document CD 6.13. Just pick up a couple of things from that. It's common ground that the NDP was now made more than 2 years ago, and therefore we're not being troubled at all with paragraph 14 issues.
Correct, and that's obviously reflected in the statement of common ground. Yes, completely agree.
Yeah, but if we look in the neighbourhood development plan at page 23, first of all,
yes,
where we can see the figure 2, the limits to development.
Yes.
We know where the appeal site is, to the south of Sileby. But we can see from that limits of development, a matter which we'll pick up on other plans in a moment, but just to note it here, that the limits of development are drawn around what appears to include open fields in some parts of the
yes,
the area.
To the northeast. Yes, I agree.
To the northeast and to the east. And then just while we're in the document, so we don't have to come back to it, if we could flick down to page 31.
Yes.
Where, sorry, page 21.
As I say.
Yeah. And just look at the position in the neighbourhood plan about housing reserve sites. It's common ground. There were no allocations within the plan, but there were reserve sites identified.
I think it is page 31, by the way. I think there's an odd page number.
Oh, it is. Sorry, yes, it is page 31. It is page 31. My note was quite correct.
There's a box that says 21, but I think that's probably
you're quite right, sir. The reserve sites and the circumstances in which those reserve sites in effect might be released.
Agreed, but go back to the previous comment. That doesn't affect the judgment, and paragraph 14 is not engaged.
That's absolutely right. And then the reserve sites are illustrated on the following page 32.
Yes.
Okay, good. Next, please. Can we look at the position in the Cossington emerging neighbourhood development plan, and that's core document 6.35. And on page 14, I think we can see an allocation of up to of a site, or a proposed allocation of a site for up to 12 dwellings.
Correct. Yes, at the sort of southwest of the village. Yes.
Yeah. Do you have an observation to make about the Humble Lane site?
Well, it's in terms of Cossington, and in terms of, well, we'll look into this in a minute, into the emerging local plan. It sits outside the settlement, the defined settlement boundary, as does this allocated site in the emerging Cossington neighbourhood plan.
That's quite right. And then lastly, I think you would, while we're in this document again, you wanted to draw the attention of the inspector to the photograph on page 30, is that right?
Yes, it's got the headline "Woodland Notable Trees and Hedges." I just think it's a very good annotation of a very good, aerial photograph of the site in question, and shows the landscape and the fields between the two villages of Sileby and Cossington. And to my mind, that shows that if the appeal site is built out, you are starting to coalesce.
Okay. Now, back then to the planning statement of common ground, if we can, please.
Yes.
And page 14 and paragraph 52 to 58.
Yes.
Again, more common ground, this time dealing with the site's, what we might call locational sustainability credentials in terms of access to services and facilities. And the fact that Sileby is one of the 7 service centres, which means it's one of the more sustainable settlements within Charnwood to provide for additional growth. That's all common ground, isn't it?
That's all common ground, yes. Locational detail or agreed, it's on the edge of a service centre. Yep, so yeah, agree with all that. Okay,
well, let's now look then at what the council's planning to do with in the future, and we know that it submitted a emerging replacement local plan for the period 2021 to 2037, submitted for independent examination in December 2021.
Correct.
And I understand that the council's examination website now shows that oral hearing sessions are fixed for late June and July of this year. Is that right?
Yeah, that's my understanding. So yeah, the dates of June and July 22 have been set for the hearing dates. It still does have the local plan adoption down as late 22, early 2023, which may well be a bit optimistic. I think a more realistic estimate is probably a new local plan in 12 months from now.
Okay, yes, the local development scheme was amended recently, but as you say, still talks about adoption in December or January, which you've described as optimistic. There's no doubt there's going to be a main modifications process. And therefore your best judgment is that it'd be better to assume that adoption will be next summer.
That's my estimate. I think it's a reasonable estimate based on the work that's been done to date and the programme that was set previously.
Okay. And what's your understanding about the examination process and its scrutiny of a 5-year housing land supply on adoption?
Yes, so Yeah, we've already discussed, and it's common ground that we do not have the 5-year housing land supply. That's the nub of the argument, really. And at adoption, with the work that's been done, with large amounts of development that are already being developed out, and sites that have resolutions to approve, that on adoption of the emerging local plan, the new local plan, there will be a 5-year housing land supply.
Yeah. Can we just look at the proposals map for the emerging local plan, which is core document 6.05?
Yeah.
And if you're clever enough, Mr. Gould, to be able to look at that plan alongside the Sileby sites plan, inquiry document 4.
Yeah, I can only do that because I've gone old school and printed off a copy of the Sileby housing map. Okay, well, if you can split your screen, anybody else can split their screen, that will be helpful to have those two documents available at the same time. Looking first then at the CD 6.05, the local plan draft policies map, and if you can find Sileby and blow it up to whatever scale fills your screen. Yes.
And we can see that first of all, that to the northeast of Sileby, underneath the capital grey words Sileby CP, we can see an area that's coloured white within the settlement boundary, but that doesn't have any houses on it on the OS map base.
Correct, and that obviously correlates directly with the approved site off Seagrove Road for 190 dwellings, which in turn is detailed in blue on ID4.
Yeah, and ID4 blue sites are, according to the key, approved housing site under construction.
Correct.
And then there's another area of what I'll refer to as white land on the east side of Sileby. And then that is Pease Hill Farm, I think, on the ID4 plan, again, coloured blue, under construction.
Correct. So there was the stems from the very beginning of the inquiry, and there were a lot of names being put forward about sites that have been built out and had approval, and I think with good reason this the Sileby housing map was, at the request of the inspector, was produced, and I think that very clearly ID4 shows a correlation between the proposals map in the emerging and the new local plan and the work that's been done by the Borough Council in progressing and trying to resolve the lack of 5-year housing land supply. In other words, working in advance of the emerging local plan.
Yeah, and then the other area or large area of blue on ID4 is Millbank Place.
Sorry for interrupting my learned friend. Can I just be clear about one point? Because I'm doing exactly what my learned friend has asked us to do, which is to look at that area of blue, which I think is the 195 Highgrove Field site on ID4, and it doesn't quite correlate to the white on the proposals map. The eastern part alongside the footpath appears to be omitted, and that also appears to omit the area of land off Seagrove Road 134 dwellings, or am I looking at the wrong plan is my question, really.
Yes, my learned friend, it is correct that there is not an exact correlation. Mr. Gould, do you know the precise reason for that?
So it is the strip of land from the sort of southwest northwest footpath, and the green area hatched to the southeast is not the white area, as you say. I don't think there's any disagreement on that. The two don't correlate, as you say, just as there's that piece of land to the bottom of that strip which isn't included in a development. I don't know the answer to that. I don't want to speculate, but it may well be something similar to the proposed development in front of us with an area of open space, but I don't want to speculate.
I have to say that may be right, because if you look at land off Seagrove Road, there appears to be on the base plan, the area of developments there, an area of open land. It was just the way that my learned friend put the question to make sure I was not looking at an incorrect plan. That's all.
Yeah. And then so that was up to the northeast. We looked in the east. We looked at Pease Hill Farm. There's another blue area on ID4 next to it at Millbank Place for 108 dwellings.
Correct. Yep.
Which again is approved and under construction. This time not shown as white land on the emerging policies map, but some washed over in green. But nonetheless, the factual position is it's being built on. Is that right?
That's correct. Yes. And yeah, so the white areas on the CD 6.05 relate to approved development that's commenced, and then in relation to the proposals map, the orange land, I mean there are several on there, but I'll just focus on the bigger ones as HA53,
yeah,
HA54 and HA59, which slips down into Cossington Lane, and one we'll all be familiar with the Humble Lane application, relate to sites with resolution to approve. So the allocations for Sileby follow the logical progression, with the barriers to development to the north, south and west of Sileby. The logical progression is, if there with the tilted balance, if there is to be development outside of the settlement boundary, the obvious progression is into the sort of northeast direction, which is exactly what's on the two maps, the two drawings that we are discussing.
Yeah, and
sorry, just to come in there, I wonder why Mr. Gould says obvious progression, or is that something you're going to come to?
Literally, because there are constraints to the development to the north of Sileby, the south of Sileby, and to the west or southwest. To the southwest, you have the sort of the floodplain. In terms of the areas to the north and south, is the areas of local separation. And what apologies if I misconstrued something here, but what I was saying is if we're having the argument, well, we are having the argument about where development goes, if it has to be outside of the settlement boundary when you engage the tilted balance, I would suggest the logical progression when you're talking about Sileby is off to the north and northeast, which is reflected in the two plans.
Okay, thank you. That's helpful. Thank you.
And we can see that with those allocations, promoters or developers have not been backward in coming forward with their planning applications. Once a draft allocation appears in the plan, and they're coloured, as you've identified, yellow on the plan ID 4, and in the key, those are sites described as, quote, granted at committee subject to signing of Section 106 agreement. What we would know as subject to a resolution to grant.
Correct.
And so it would appear that the council is perfectly happy to progress these sites.
Yes,
alongside the emerging local plan.
Correct. I think what I say is the council is being proactive in planning for growth in Sileby, and both of those documents, ID4 and CD 6.05, clearly show this. As you also made reference to, there have been many representations to have sites allocated in the emerging local plan. Of course, the appeal site being one of them. So there's a long history of development in this area, but we don't consider that the appeal site is the appropriate location for the reasons that have been given.
Yeah. And now if we then go back to the statement of common ground, the planning statement of common ground, and paragraph 50 at the bottom of page 13.
Yes.
We can see that it's common ground that the draft local plan has been submitted to the Secretary of State, who waits full scrutiny. It's therefore agreed that it can only be afforded limited weight as a material consideration in this appeal. So I'm not proposing to look at policies in the plan, but insofar as the inspector may be interested in how long the failure to demonstrate a 5-year supply of deliverable sites for housing is concerned, how long this undesirable state of affairs is likely to last, what's your best judgment in terms of the action that the council is taking to address that?
Okay. So 2 points on that. I think we touched upon it at the beginning in terms of the best guess, educated guess on when the new local plan will be adopted. So firstly, I think we'll be in a situation in approximately a year's time when the local plan is adopted, there will be a 5-year housing land supply. And secondly, the reason there will be is because the council is being proactive. It is making difficult decisions. It's not shying away from those. The development, not just in and around Sileby and around the rest of the borough, but the applications that have gone to planning committee are making those difficult decisions, which and the approved and being developed, and those with a resolution to approve clearly shows that in the immediate location in and around Sileby.
All right. Good. Let's leave that and move to the next topic, which is the presumption in favour of sustainable development.
Okay.
And we know that requires a balancing of adverse impacts and benefits.
Correct. Yes.
And the adverse impacts are what, in your view?
So the adverse impacts are firstly, obviously, the area of local separation. That is, again, is the nub of the argument and is disputed. Secondly, the landscape character and appearance impacts. Again, that's disputed. And thirdly, the loss of best and most versatile agricultural land. But that, I would say, is paragraph 79 of the Statement of Common Ground agrees that. So I think by default, there are two key impacts. It's the impact on the area of local separation, and then secondly, the landscape character and appearance impacts.
Yes, and as you say, the agricultural land quality position is agreed at paragraph 79 in the Statement of Common Ground. So those are the adverse impacts, and as you made clear at the beginning, you're largely reliant on Mr. Higson for the nature of the impacts so far as the first two are concerned.
Yes, absolutely. Yes, I've liaised closely with Mr. Higson. Okay.
Turning then to the benefits, where the inspector will be helped, we hope, by paragraph 89 of the Statement of Common Ground.
Yes.
Just to run through the benefits and perhaps give an indication as to what weight you think ought to be attributed to them.
Okay, so obviously, as part of the tilted balance arguments, it's the adverse impacts and then the benefits. So I think, whilst they are stated in the Statements of Common Ground, I think it is worth going over these. So the benefits: provision of market housing, so up to 119 units. As was already said in the Statement of Common Ground, the council can only demonstrate a 3.34 year supply. That's in paragraph 14 in the Statement of Common Ground. but it is granting planning permissions, and that's in my statements para 8.2 and 7.2. I think it's a comment I made just actually that the borough council are being proactive. They are taking the difficult decisions in light of the lack of 5-year housing land supply. So then in that respect, in terms of the provision of market housing, and I made it clear in my paragraph 7.2 of my proof, significant positive weight. So as I say, we're not shying away from the difficult decisions, and we're not ignoring the obvious fact here.
Okay, so that's market housing, and then there's going to be affordable housing as well.
Yeah, so provision of 30% affordable housing, which is policy compliant, and that'd be up to 51 units. This is a matter which merits significant weight, and the breakdown, the tenure of that, I believe, sits within the draft wording of the section 106.
Okay, and other benefits, what's next that you agree?
The development is at a service centre. I mean, that's clear. And the paragraphs 53 to 58 of the statements of common ground talk about the location, sustainable location within walking and cycling distance of a range of services and facilities, including a primary school. Next, I would say there's the economic arm of that argument on sustainable development. Again, that's paragraph 68 of the statement of common ground. In my statement, paragraph 77.3, I give it limited weight as to quite the economic uplift from this development. And then lastly, the biodiversity net gain, statement of common ground, paragraph 85. My paragraph 7.5, I give it moderate weight in my proof.
Yes, and then if we turn over to page 20 in the statement of common ground, which is chapter 5, the matters on which the parties disagree, and paragraph 93 addresses the benefits on which there is disagreement. What comments do you have to make on that?
Yes, so there are essentially 4, if I go through in turn for May. So the new green infrastructure for existing residents. I'm not quite sure what that means, if there's an existing shortfall for the residents that live in Sileby already. For that reason, my para 7.6 to give that moderate weight.
Okay.
The landscape improvement by planting, as has been indicated, I would defer that to Mr. Higson's evidence. And similarly, the improvement to the settlement edge, something I would refer to Mr. Higson's evidence in chief. And then the housing development as within walking distance of the primary schools, I've already covered, just actually, and that sits in the statement of common ground. There's
yes, you've accepted that the development is at a service centre and within walking and cycling distance of a range of services and facilities.
Correct.
Do you think there's any reason to single out primary school for double counting?
I'd rather not get drawn on that one. I think I'd leave that for the education specialists to.
All right. Okay. Now, so those are the matters that go into the balance, and then the decision taker or the exerciser of the planning judgment has to decide whether the adverse impacts significantly and demonstrably outweigh the benefits.
Correct.
But we know that this site is outside the limit of development policies in the local plan and the neighbourhood plan. How much weight do you give that as a fact in your balance?
It's well, significant weight. It is outside the development, the defined settlement boundaries, but then that comes into the tilted balance and the balance of the argument when there is no 5-year housing land supply and para 11D.
Yeah. In your evidence at paragraph 8.4, I think you consider the issue of restrictive policies.
Yep.
What are you explaining to the inspector there?
So in this situation, when the tilted balance is engaged, it's something I mentioned at the beginning of our discussion. It doesn't automatically follow that a refusal is automatically the decision. So it's an important consideration. But it can, with appropriate reasoning, the decision maker refuse an application notwithstanding the tilted balance being engaged.
Okay. Lastly, how would you characterize in terms of time, the adverse impacts and the benefits that would arise from granting planning permission in this case?
Okay, so I think no doubt this will be debated in a bit, but my best estimate is that we're probably 12 months away from adoption of the new local plan. The new local plan, on adoption, there will be a 5-year housing land supply, and that's largely due to the proactive work and the difficult decisions that have been made by the Borough Council in putting forward sites and approving and resolutions to approve for housing development in that area. So I would suggest that there is a 12-month window where permanent harm can be done to this site, after which we would have a 5-year housing land supply and the development would follow in course with the proposals map and the development that's been approved and resolutions approved as on the drawings ID4.
And what about the length of time by comparison that the adverse impacts would persist for?
Well, clearly in perpetuity. If the appeal is allowed, if the development is completed, it's there forever.
Okay. Good. Mr. Gould, I think that's everything that I wanted to ask you about in Chief. So perhaps you'd be good enough to wait there and await the inspector's further instructions.
Thank you, Mr. Richards. Mr. Tucker, are you happy to start cross-examination, and then perhaps we sort of break around about 11 o'clock at a suitable point?
Yeah, more than happy to do that, sir. I'd certainly prefer to make a start rather than breaking early.
Sure. I think we can do that. That's not a problem. So yes, when you're ready, please begin, Mr. Tucker.
Thank you very much, and good morning, Mr. Gould.
Good morning, Mr. Tucker.
Mr. Gould, can I just pick up a couple of points from your examination in chief at the very outset, and just to understand the point, you are reliant upon but not repeating the evidence of Mr. Higson, and his conclusions underpin your planning judgment. Is that fair?
Correct, yes.
And the two issues which you identify as being the principal harms which arise in this case, the effect on the area of local separation and the effect on character and appearance, fall very much within the sphere of the debate between Messrs. Cook and Higson, don't they?
Correct. Yes, I think all parties have heard the arguments on both sides of that. Yes.
Exactly. So is it fair to say, and this is not seeking to draw stumps at 25 to 11, you'd be pleased to hear, the determinative issues in this case really depend upon the outcome of that debate, don't they?
Yes, but clearly there was a planning argument to be faced as well. I was reading through the documents, as no doubt we all have, as in preparation yesterday, and I note from your opening statement that the matters pertaining to landscape character and impact form 75 to 80% perhaps of your case. So yes, I would agree that's the key factor.
Yeah, if Mr. Higson's right, you win. If Mr. Cook's right, we win. Is that a fair assessment of the planning judgment between us?
Well, clearly that's a judgment for the inspector.
No, I'm not going to let you away with that sidestep, I'm afraid. It's your planning judgment I'm asking for. If plainly you're here to assist the inspector, you've given a statement of truth as to your planning judgment, you would give your evidence whether you're acting on behalf of the appellant or the local authority. If the inspector accepts the evidence of Mr. Cook rather than Mr. Higson, the appeal should be allowed, shouldn't it?
I would agree, yes.
Yeah, good. Thank you. That's helpful. Yeah. Next point, if I may, just picking up a point that arose from your discourse about the Cossington neighbourhood plan and also the plans that you looked at. So your point on core document CD 6.35, and you don't need to turn it up unless you've got a burning desire to do so, on page 14 of it, was to point out that in Cossington there's an allocation in the emerging neighbourhood plan which isn't Humble Lane. Humble Lane isn't shown at all. It's beyond the settlement boundaries. Yeah?
Yes.
And one of the points in relation to Humble Lane is that there is a standoff between the north end of the proposed development and where the brook lies.
Correct. And then there's a barrier off to the side adjacent to the railway.
Absolutely. So there's that degree of open land standoff. Now, we know that the appeal scheme also has an area of open land standoff south of the built form of development, north of the brook, don't we?
Correct. Yes.
Now, let's just look at the plans that you took us to in relation to the comparison between ID4 and core document 6.05. So let me take you back to that, if I may.
Yes. Yeah, got those, yeah.
Good. If you just excuse me catching up with myself. Now, I intervened just to make sure I was looking at the right plan, because when we look at ID4, what seems to have happened in relation to the land off Seagrove Road, the 134 dwellings, appears to be that a conscious decision has been taken by the council in drawing settlement boundaries in the emerging plan to exclude the open area of land which lies between the built form of development on land of Seagrove Road and the proposed allocation of land off Bernard's Drive. Is that a fair inference from the information that we've got before us?
That's a fair inference, yes. So it follows on from the same footpath, the southwest northeast footpath from the blue plot you talked about previously. That's a fair inference.
Yeah, and we don't know what the inference is in relation to why the eastern area of that northern blue area has been excluded, but it may be something similar. But just to be clear about the last point that you raised with Malone and Friend, adverse effects are going to be forever. The harm that it seeks, the problem that it's seeking to address is only 12 months. And I'm going to come back to the period of time in a moment, because I'll take that bet from you if you want a side bet behind the scenes, Mr. Gould. But just picking up that point, it is certainly the case, isn't it, that if we were thinking about an appeal allowed world and a Humble Lane consented and built world, that there would remain, would there not, areas of open land, i.e. land without built form on them, north and south of the brook, separating the built forms of both Cossington and Sileby. That's fair, isn't it?
Well, in answer to your question, yes, there would be. And
elsewhere in the settlement, it would appear that the authority has seen fit, notwithstanding it lies within the consented area of a planning consent, to exclude an open area of land. It would seem between the the 134 consent and the allocation HA 53. You see that?
Yeah, well, yeah, as I answered, that inference would seem to be correct, yes. I think there's a counter argument to that, in that developments of this site, residential developments of this size and nature, will always have an element of recreational, outdoor space, etc. I think the appeal site is different in that that strip is along the bottom, which in turn forms the area, a key function in the area of local separation.
And the issue between us, really the Higgs and Cook debate, is the effectiveness, isn't it, of that area of land south of the built form of development we proposed, the land north of Humble Lane, which is resolved to be consented, and also the remaining open land, which lies to the west of Cossington Road. That's the issue of debate the inspector needs to form a view on, doesn't he?
Yes, and I think there's also, not wanting to stray into sort of landscape details, but I think there's also an issue around, but having said that, issue around the treatment and appearance of that remaining strip.
Of course, and the inspector will form a view in relation to that. But if we then go to the other point that you raised in your examination in chief, which the inspector said, just can I understand what you're saying in relation to that? If the view is formed by the inspector that the proposed open land south of the built form of our scheme, that north of Humble Lane, and the remaining open land, so the brook, the land to the west of Cossington Road, etc., do maintain an effective separation between the two settlements. So if he forms that view, then the constraint that you identify to the south will have been resolved, won't it?
I mean, obviously, that's not what we'd be seeking. That's not. But if he was to take that view, I would still be of the opinion that there is still a perceived coalescence. Well,
hold on. If the inspector considers it to be effective, I'm encompassing within that both actual and perceived separation. OK, so if the inspector considers that the area of land which is retained open as a result of both Humble Lane and the appeals site and the remaining open land which sits between the settlements is effective to maintain the separate identities of the settlement, so there is an effective separation, in those circumstances there would not be that constraint insofar as it relates to the built form of development proposed. It's almost a truism, isn't it, Mr. Gould?
Well, it is a truism, yes. It's clearly it's not necessarily something I would agree with, but I accept that in that situation that would be the case.
But just picking up other points that you told us, and we don't necessarily disagree with that, if you were looking for other areas of land around Sileby, the inspector can note, can he not, that the land to the west of Sileby is constrained by floodplain, as you told us.
Yes.
And the further one goes to the northeast of Sileby in terms of development proposals, the further one goes away from the facilities within the centre of Sileby, doesn't one?
Yes, so I suppose that's an argument about infrastructure and sustainability. It's then obviously down to those individual applications to ensure that they respond to that. Yeah,
so it's important, isn't it, that a balanced judgment which takes account of all those factors when looking at whereabouts you should be expanding the settlement should be taken, shouldn't it?
That's a reasonable argument, yes.
Yeah, thank you, that's helpful. I should say, by the way, I'm not in any way wanting to engage with looking at these plans, but it might be an exercise that you and Ms Smedley engage in. If you look at ID4 and you look at the proposals map of the emerging plan, the discrepancies which exist in terms of the two plans don't just extend to that area of green space. There are other discrepancies. For example, the land to the north, the extreme north of Sileby, etc. But there's other areas. It may just be worthwhile behind the scenes, you and Ms Smedley just having a quick look at that, if that's okay.
I think that's a fair point. Yeah. Obviously, with the remainder of the week allocated to this inquiry, that's certainly something I can pick up either later today or tomorrow. Yes.
Good stuff. Next point arising from your examination in chief, and I will pick up timescales in a few moments. Just to get this schedule right. So the emerging local plan submitted in December 2021. There was then a fairly detailed letter from the examination inspectors, 2 of them, in February 2022, asking for more information on 5-year land supply. There was a response from the council and then a further letter from the inspectors saying, can we have some more information on 5-year land supply? And the response to that, which is at the start of March from the council, was we will provide the information by the 29th of April. Now, you can check that behind the scenes if you want. But the information that my learned friend has drawn attention to this morning, i.e. the information on 5-year land supply, is presumably the same information that's being sought by the local plan examiners. Agreed?
That's right. That's my understanding, yes.
Right. So in terms of the information before the local plan examiners, we don't know what their view is on the adequacy of that information or whether they'll be writing another letter asking for more information, do we?
Well, no, we also don't know whether they're going to agree that it is okay, but yes, I agree.
Yeah, we just don't know, do we? And we also don't know what the views of consultees who are directly affected by that debate would be, do we?
No, clearly, no, we don't.
And the level of scrutiny of that information lies outside of the scope of this inquiry. Everybody will be disappointed to hear and will be part of the examination, won't it?
Yep, and the hearings and the dates that have been set, yes.
So as we sit here today, there is presently information that's being sought by the local planning examiners, which hasn't yet been provided on the issue of 5-year land supply. And we still don't know what the view of the local planning examiners would be as the adequacy of that information. That's the factual position sitting here today, isn't it?
Yes, it is. Sorry, the last part of that, Wayne, I don't know if it's a fault at my end, but yes, that's the factual position we're in today. But as Mr. Richards mentioned, it's unlikely to materially change.
No. The 5-year land supply claim by the council is unlikely to be changed. That's a different point. The point is, in terms of an argument as to whether the council can demonstrate 5-year land supply on adoption, which is the point that you've raised in chief, the point that you're optimistic is going to be resolved by July of next year, there's an evidential lacuna sitting here today, which we don't know what the inspector's view would be in relation to that, and we're still a way off the examination itself, aren't we?
Understood, yes.
And that adds to the degree of uncertainty as to whether that will be resolved within a comparatively short timescale. Necessarily, doesn't it? Yeah.
It does add to one level of uncertainty. Sorry, I'm getting a bit a crazy echo. I don't know if anyone's got the. Sorry. That's better. Whatever's happened, I think. Yeah.
Happily, I've not done anything because I pressed the wrong computer. So if it's down to somebody else that's to blame. Yeah. So my point, just to repeat that to avoid the crazy echo, is this uncertainty, this additional evidential lacuna, as I've characterised it, adds to the uncertainty as to whether the council will be able to demonstrate a 5-year land supply on adoption within the timescales that you've identified.
Yeah, it's not an exact science at this moment in time. There are several unknowns, and this is one of them.
Okay, good stuff. Yeah, good. Right, down to cross-examination proper, you'll be pleased to hear. Now, we know that the officer's report tells us that the case officer was Denise Knipe, and I'm assuming you're not Denise Knipe. You're not the case officer, are you?
Certainly not.
And you tell us that you aren't an employee of the council. You're an independent practitioner, giving your own professional view, having come into this. So, but what you don't tell us in your proof is why you're here, Mr. Gould. So what's your involvement in this case? Was it pre or post appeal? Post
appeal. Sorry, it's a fair point. Yeah, we were procured by the Borough Council to defend this appeal.
OK, and enigmatically, you don't tell us why the council aren't giving evidence. No difficulty there. Any professional planner will do, as it were, providing their professional judgment. But you don't tell us why it is that the council aren't providing internal evidence.
No, we were asked to do that. We put forward a proposal and it was accepted. OK, and before you put forward a proposal, what steps did you take in terms of the nature of the case? Obviously, a quick read through of where we are, have a look at the start letter and look at the dates, and internally to see if we have the resources and the time to work on this. Well, that's helpful, but it wasn't really what I was directed towards.
Self-evidently, you didn't have the benefit of Mr. Higson's view at that stage, but you would have presumably had to satisfy yourself that you professionally concurred with the view of the case officer before accepting instructions.
I agreed with the flow of the argument and the conclusion they came to in the officer's report, yes.
Okay, so you looked at the officer's report. Did you go to site before accepting the instructions?
I did not, no.
Okay. But nonetheless, you have done now, and nonetheless, you have the benefit of reliance upon Mr. Higson's evidence. So that only takes us so far. Thank you for that. That's helpful. Second reason for refusal has fallen away or will fall away with the 106. You tell us that within your proof of evidence at 2.2. So the only issue between us is the first reason for refusal, isn't it?
Correct, yes.
And you don't invite dismissal on any other basis apart from the first reason for refusal, do you?
Correct, yes.
Good. And you don't allege that there is any conflict, policy conflict, other than that which is set out within the first reason for refusal, do you?
Which follows on from the officer's report and the flow of the argument to their recommendation.
No, it does. But sometimes when you get somebody else coming into a case, they say, "Oh, well, you've missed that," or you get officers that say, "I've missed 4 policies in the reasons for refusal," as I have in a couple of weeks' time. But you're not arguing that. You're saying the right policies which are alleged to be breached are those set out in the reasons for refusal. Do you agree?
Yes.
Thank you. So where we see in the statement of common ground other policies that are identified as being of relevance, those are either not engaged or not breached. Is that fair?
We may get on to these the specifics of those. Some are cross-reference, some cross-reference each other. But generally speaking, yes, I would agree with you.
Yeah, okay, good stuff. And we can also agree, can't we, that save for the issue embodied by the first reason for refusal, there's no technical justification for withholding consent, ecology, ground conditions, highways, or anything of that nature, is there?
No, I'd agree with that.
Good. So essentially, we need to explore 7 policies, 2 from the core strategy, 2 from the Save Local Plan, and 2 from the NDP. Agreed?
Agreed, yeah.
Right, good. Let's have a look, if we can, first of all, at the local plan. And we'll probably just get through this before 11 o'clock, which may be an appropriate moment to break. So it's on my learner friends list, and I should have said that my list of documents is the same as his. So I think we should have all the documents out. If I've failed in that aspiration, I apologise in advance. So it's core document 6.01. And the policies which are identified to be breached are ST2, CT1 and CT4. ST2. Now you get that. I don't know if you've got it on the PDF or in a hard copy. If you've got the hard copy, it's page 22 of the Save policy of the local plan. If it's the PDF, it's page 29.
Yes, we've got that.
Okay, the Charnwood local plan adopted in 2005, or in some places it says it's adopted in 2004, interestingly, is of some vintage, isn't it?
Clearly, yes.
Its plan period covers the period from the time when Margaret Thatcher was still the Prime Minister, 1991, all the way to 2006. And it's based upon a needs assessment, a development requirements assessment, which is now hopelessly out of date, isn't it?
I would agree that it's an old document, but I'd be probably going on to the Save policies aspect of this anyway.
Well, I asked a specific question. I'm going to ask it again. You've been very helpful in terms of direct answers to direct questions, as the inspector reminders on day 1. So I'll repeat my direct question. It is based upon development requirements which are now hopelessly out of date, isn't it?
They are out of date policies there, yes.
Well, they're out of date. What adjective would you apply if not hopelessly? Extremely? Dramatically?
No, I think if there are policies that have been brought forward and saved, then how can they be hopelessly out of date?
Well, because when the saving directions were issued in 2007 by government, Government expressly said that that's not taking a view on the up-to-dateness of policies. It's saving them from administrative convenience, whilst the new LDF system got into swing, and we're all going to have development plans adopted within a year, as the Labour Party had then told us. That happened, didn't it? So the basis of that local plan is certainly very out of date, hopelessly out of date, extremely out of date. How would you express something based upon what was a precursor to regional guidance?
Well, I would agree that they are out of date, and taking those three options, I'd go with very. Very.
Okay, that's fine. I'm happy with that. And it follows, therefore, doesn't it, that the geographical limits of settlements within the plan, so not necessarily the development management policies themselves, but the geographical limits of the settlement boundaries need to be viewed in the context of the fact that they are based upon development land requirements that are out of date. Agreed?
In this particular policy, because obviously well, no doubt we'll go through them one by one, but so ST2, it's based on geographical limits that are out of date.
Thank you. And we know that they're out of date because you pointed us to the neighbourhood development plan in chief, so I don't need to point to you again. So the settlement limits of Sileby established by this document, which policy ST2 relates to, are agreed between us to be out of date, aren't they?
Correct.
Thank you. And if we wanted any further confirmation of that, we can look as closely as Humble Lane to see that the authority has granted multiple consents beyond settlement limits in Sileby and about to do so in Cossington, which demonstrates the settlement limits are out of date in terms of modern up-to-date needs. Agreed?
Agreed, yeah, and it's not just Sileby and Cossington; it's across the borough, and I think it's something I've said. You know, it's the authority are taking those difficult decisions in relation to settlement developments outside settlement boundaries.
Absolutely, because in an ideal world, government should have been right when they saved policies in 2007 that we'd have development plans in place by 2008. You always wonder what goes across ministerial desks. So insofar as there is a breach of ST2, it has to be viewed in that context, doesn't it? i.e. it's a breach of settlement limits which we agree are out of date.
Taken in that context, agreed.
Yeah. CT1, which I have as page 107 on the hard copy and 114 on the PDF.
Okay.
All the joys of scrolling with your right hand whilst not looking at a document is you scroll immediately past it. Right, CT1, this is a precursor we can see from the title of before CT1 for a section of the plan which deals with countryside generally, green wedges and areas of local separation. Agreed?
Agreed, yeah.
And CT1 is a policy which is engaged whether you're in an area of local separation, a green wedge or an area of countryside. Agreed?
Agreed.
And if you look at paragraph 6.13 to see the underlying policy requirements which informed CT1, it's the former need to protect the countryside for its own sake. Do you see that?
So what page is that one on?
That's the paragraph immediately following CT1, page 114 of the PDF. National policy guidance emphasises the need to protect the countryside for its own sake.
Yeah, so I'd gone old school and was on a hard copy. So the preamble I haven't got. But yes.
Yeah. Well, there's two paragraphs I just want to draw attention to. I'll read out the sentences in full and my learner friend will tell me if I'm not reading them out correctly. So the first point on that sentence, though, is that doesn't represent current guidance in relation to the countryside, does it?
As we've discussed already, yes.
Yeah, 6.15, just to see what the aim is for development generally beyond the settlement limits. It says the guiding principles within these areas, countryside, green wedge, area of local separation, the guiding principles within these areas of essentially open land will be to ensure that new development is small scale and does not adversely affect the appearance and character of the landscape. Okay, see that?
Yes.
Good. And let's look at what the policy itself does. It says, first is outside of defined limits. This applies. development within these areas of generally open land will be strictly controlled, and tells us that you can have reuse, etc. And then it says, and small scale new built development. And then we've got examples of where you can have development which is needed in these areas. Then says, in all cases, it should be demonstrated the proposed development could not reasonably be located within or adjacent to an existing settlement. Okay.
Okay. Yes, that's there. Yeah.
So let's just think about those two elements then. So the first bit, there is a strict control that's being imposed in respect of these areas and an aim to keep development small scale in all areas beyond settlement boundaries, which we've agreed are out of date. Agreed?
Agreed. Yeah, it's not the reuse or adaptation of rural buildings. So yes.
Then it's in all cases, it should be demonstrated the proposed development shouldn't be reasonably located. So even if you're proposing just an agricultural development within or adjacent to an existing settlement. So in all of these areas, there's this requirement to prove development inside a settlement or on the edge of a settlement.
Agreed.
On any view, the appeal proposals are adjacent to a settlement. Agreed?
Agreed. Yeah, on the periphery of the service centre, which I think I said earlier. Yes.
Yeah. And in terms of demonstrating that the proposed development couldn't be reasonably located within an existing settlement, it's a point you do pick up in your proof of evidence, but it's not a part of the reason for refusal that you're praying and aiding, is it? You're not saying we haven't provided a piece of work to show that we can't develop a site of this scale within Shepshed, Loughborough, or somewhere else within the borough. That's no part of your case, is it?
No, I think what you're saying is that's not reflected in the reason for refusal, and I would agree.
Yeah, good. So the part of CT1 which is being alleged to be breached is its development in an area which will be strictly controlled and should be small scale.
Taking that argument, yes.
Yeah, good. Right, that's what I thought was the position. And that's an undifferentiated argument based upon a policy based upon out-of-date national guidance. Agreed?
As stated before, yes.
Yeah, good. So again, that's breach of an out-of-date policy. You give diminished weight to breach of an out-of-date policy, don't you?
Yeah, as para 11, yeah.
Okay. CT4 next, skipping over CT2 and CT3, but I am going to come back to CT2. We've looked at CT4 briefly, but I am going to compare and contrast CT4 with CS11, where it says CT4, which is page 116, in areas of local separation, development acceptable in principle will only be permitted where the location, scale and development would ensure that, and then we've got the two criteria, predominantly open and undeveloped character of the area is retained and the already narrow gap is not reduced. And then we've got Sileby, Cossington is one of those gaps. Yeah.
Yep.
So development is only in principle acceptable within the area of local separation if it meets those two criteria. Yeah.
Yes.
But if it does meet those two criteria, then it's acceptable, isn't it?
That's the logical progression.
Right. Let's deal with some logic. Because this is specifically dealing with an area of land which is designated on the plan, the narrow gap between the settlements isn't reduced. So it's specifically asking ourselves whether or not a development could come forward which doesn't reduce that. One can't have the conclusion, can one, that merely building in the gap on the designated land breaches criterion 2. Otherwise, it will be a nonsense policy, wouldn't it?
So I don't quite follow your question, so just bear with me a second. So in areas of local separation, development acceptance principle will only be permitted where the location, scale and design would ensure that the already narrow gap between the settlements is not reduced.
Yeah. It's not saying you cannot build on any area of the area of local separation. There is a judgment call that's being called for as to whether a form of development coming forward in the designated area has the effect of criteria number 2. Do you agree?
And that makes more sense to me now. So yes, I agree. There's a judgment call, and that's well, that's exactly the nub of the argument here as to whether. Yeah.
Good. And similarly, the first criterion requires a judgment call, doesn't it? It requires you to identify what is the predominantly open and undeveloped character of the area. Come back to what's meant by that. Let's assume it's the designated area for a moment. Is retained. that's also a judgment call, isn't it? Because you can have a reduction in what the physical area is whilst it retains predominantly open and undeveloped character.
That, in theory, could be achieved, yes.
Now, in terms of the area, that appears to be a word which is of wider use, because it doesn't say the area of separation, it says the area. So should one have regard to, in applying that policy, area of land which isn't identified within the area of local separation but is alongside it?
Right. In accordance with the wording of that policy, yes.
Yeah, good. So let's apply it in the context of this. We know that the Arup report suggested that land should be added to the area of local separation, but wasn't. And we also know that land south of Humble Lane, not in the area of local separation, is going to have an area of open land south of the brook. So there's a logic in this case to applying that criteria, mindful of not just the designated area, but the area of land which lies alongside it, which is visually contiguous with it. Do you agree?
Yeah, and helps perform the same function. But yes, that's the disagreement as to whether that does that or not. But yes.
Good. Go back to CT2 for a moment. CT2 says in areas defined as countryside, so we've got the third of the area of these three areas. It says development acceptable in principle will be permitted where it would not harm the character and appearance of the countryside. So there is a no harm view that's taken in relation to the countryside generally. Whatever view one might form, that's absolutely not in accordance with NPPF, is it?
Well, it would not harm the character and appearance of the countryside and provided it could safeguard its etc. etc. So,
yeah.
So what was your question?
That's absolutely not in accordance with paragraph 174 of NPPF, is it? Which has the two-tiered structure, one of which is recognise the intrinsic character and beauty, but isn't a preclusion on development. And the next stage is for valued landscape, you protect them.
I see. Well, in that respect, as has already been mentioned, I would concur with Mr. Higson's comments in terms of the valued landscape.
Yeah.
So in that respect, I probably wouldn't agree with you in that respect.
Well, insofar as it relates to valued landscape, I can see your argument that protection and not harming are similar. But the point is, for the generality of the countryside, that's out of keeping with NPPF because it doesn't meet the first criterion of 174, does it?
Understood. So in the generality, as I think we said at the beginning, the sort of the cross-examination proper, I would agree with you.
Yeah, good. I'm going to turn to the core strategy, but looking at the time, apologies for transgressing a little beyond 11 o'clock. So that will be an appropriate moment to break. Thank you, Mr. Gould.
Thank you.
Thank you, Mr. Tucker and Mr. Gould. Yes, we'll break now for half an hour and come back at 11:40. Obviously, Mr. Gould, you've already indicated that you're sort of cut off from everybody else, but obviously that obviously applies during breaks as well. As you know.
Absolutely, sir. Yeah.
Thank you. Unless there are any procedural points anyone has before we adjourn, then we'll adjourn and come back at 11:40. Thank you.
Okay. Thank you, sir.
Hello everyone, it's 11:40 and the inquiry is resumed. Mr. Richards, do you know whether the laptop got rebooted over the break and whether people can both see and hear me?
I don't know, but it'll be checked. My WhatsApp group has not lit up to tell me. Oh, wait a minute, I'm just getting another WhatsApp. Yes, it's fine.
Oh, good. I think okay, everyone can see and hear me. Good. That's fine. I looked back at the recording during the break and I could see that obviously I was audible throughout, so I think that's fine. I don't think there's any concern otherwise. So good to know that it's back to normal. Thank you. Any other procedural points from anybody before we return to the cross-examination?
No, sir. And just to give you a flavour as to how long we've got, I would have thought that we're going to take no more than an hour at most.
Okay, thank you. That's helpful to know. In which case, if you're ready, please continue, Mr. Tucker.
By all means, Mr. Gould, good morning again. Can we turn to the core strategy, please? Which I have as excellent. And the policies which are alleged to be breached are CS1 and CS11. If you've got those to hand. So, firstly, we are within the plan period of the core strategy, aren't we? Because that's 2011 to 2028.
Yes, we are. Yeah.
However, the plan was adopted as recently as 2015 and is therefore more than 5 years old. So for the purposes of 5-year land supply, it's the LHN which is engaged, isn't it?
Yes.
And I think we're agreed that the plan itself, the need assessment of the plan, is also out of date, isn't it? Based upon a SHMA from nearly 10 years ago.
Yes, we discussed that. Yes.
Yeah, thank you. That's helpful. Yeah. And if one wanted any further confirmation in relation to that, the requirement of the core strategy, the housing requirement, is 820 houses per annum. That's now being upped to 1,111 in the emerging local plan, isn't it?
For Sileby, yes.
Yeah.
Yes.
Well, not for Sileby, for Charnwood.
Charnwood, sorry, yeah. I was as in the figure used in the assessment per year, yes.
Yeah, the requirement goes from 820 to significantly higher. And our understanding is that's based upon the local housing needs approach, as you would expect for an emerging local plan post 2018.
Correct. Yeah.
Yeah. Good. If there is any inconsistency in approach between the local plan and the core strategy, so if there was to be thought to be any inconsistency between particularly CT4 and CS11, then it would be CS11 that prevails, wouldn't it? Because it's adopted later in time.
Yes, that's very much follows on from the work done on CT4, but yes.
Good. Okay, so CS1 first of all, which I have as page 31 of the PDF, page 30 of the hard copy if you're still old school.
Yep.
And CS1 is the development strategy of the plan itself. And we can see that it starts off with development close to the Leicester principal urban area. And that deals with the sustainable urban extensions, doesn't it?
Yes. Yeah.
We've then got Loughborough and Shepshed, the two largest settlements within the district, and development directed towards them. Again, sustainable urban extension time. Agreed?
Agreed.
And then the next one down is the service centres. So below the largest settlements in the district, we have development being directed towards the service areas. Agreed?
Agreed.
And then below that, we've got the other settlements, which are there listed, and then the small villages and hamlets, and then everything else after that. So we've got a hierarchy of development, haven't we?
Yes.
And in terms of the role of the service centres in that hierarchy, we can see that the intention of CS1, looking at the words under the title service centres, is an intention to plan positively for the role of the service centres. And that's explained in the text because they've got sustainable facilities. And it said that it will do this by providing for at least 3,000 new homes and approximately 7 hectares of employment within and adjoining the service centres. You see that?
Agreed, yes.
Okay. Now, firstly, the 3,000 new homes is in the context of planning positively. Agreed?
Agreed, but it's not a target, but yes, agreed.
It's also not a ceiling, is it?
It's not, no.
Thank you. So if there is an exceedance of 3,000, one doesn't breach the policy, does one?
No.
Now, we know that, as a matter of fact, because you tell us that so far there's been 4,400 odd units that have been consented within these service centres. Agreed?
Correct. Yes.
It's no part of the reason for refusal, is it, that what is proposed by this development would result in a disproportionate expansion of Sileby? That's no part of your case, is it?
It's mentioned in my proof of evidence. It doesn't sit within the reason for refusal.
Yeah, so it's not a determinative issue in this case, is it?
It's not determinative. I would say it's important background information.
Yeah, but it doesn't, in any event, result in a breach of CS1, does it?
Well, I've already agreed. Yes.
You see, I'm struggling to understand how there is a breach of CS1, because we've got development adjacent to a service centre, not resulting in a breach of a maximum part of the policy, and it's not alleged to be a reason for refusal that it's somehow out of kilter with the role of a service centre. So how is there a breach of CS1, which isn't really a development management policy, is it?
I would argue it's to do with the amount of development that's already been approved. I accept there's no ceiling to the amount of development within this particular service centre, but it's and I think the maps that we spoke around this morning clearly identify the amount of development that's occurring within and around Sileby. So I would say, and I take your point, it's not the determinative issue, but I would say it forms strong background information as to why this would be an issue.
Can you turn to your paragraph 4.3, please, Mr. Gould?
Yes.
Which sets out the first reason for refusal.
Yep.
The first reason for refusal, as you told my learned friend in examination in chief, doesn't relate to anything with regard to previous development in Sileby, the scope of Sileby to accommodate development, or indeed the role of Sileby within the hierarchy. And I know that you pick it up as an issue in your evidence, but the breach of policy which is said to arise from the harm described in the reason for refusal isn't a breach of CS1 at all, is it?
On that point, in that context, I'd agree.
So going back to what you told me at the very outset, you're not inviting dismissal of the appeal on the basis of some other breach of CS1, are you?
That's a fair argument.
Yeah. Or rather, let's put it in an equally fair point. If you look at CS1 in a bit more detail, I skipped rapidly over the early parts of CS1. We've got a number of SUEs that are expected, sustainable urban extensions that are expected to have delivered. If you look at the first part of CS1, 4,500 northeast of Leicester, 1,500 at Birstall, 3,000 west of Loughborough, etc. And the trajectory at the back of the plan expected that those would have delivered about 2,500 units to date. But in fact, they haven't delivered any, have they?
Not yet, no. 2 out of the 3 have commenced.
But in terms of actually delivering units on the ground, none of them have delivered, have they?
No, I've accepted that already. No, but they have commenced on 2 out of those 3.
So just, sorry, I keep getting Councillor Astle bouncing up in front of me.
Same.
The irony is it keeps saying I can't verify this person's identity. I didn't even know Teams verified your identity. But it's really just to put into context your point in your evidence to say, well, we're well in excess of the 3,000 figure in CS1, but that 3,000 figure was predicated on the assumption that there would be significant delivery of the SUEs by now, and none of them have delivered anything as of today's date. Is that a fair context to put the point that you raised in your proof, Mr. Gould?
It's fair context, I think, to say the delivery of the SUEs is perhaps not what was anticipated when this the core strategy was adopted. That said, a huge amount of work has been done on the 3 SUEs. This year they will all be all 3 will be commencing, but like I say, 2 out of the 3 will be. That doesn't deflect from the pressure that Sileby is experiencing with the amount of housing that's being approved and being built.
And we know, don't we, that it's no part of the approach of the authority in submitting a plan that it thinks is sound to say that Sileby's had enough development and it shouldn't expand further, because in fact there is significant additional development being directed towards Sileby, isn't there?
As we discussed, yeah, and as indicated on, well, in particular on IB4, the nub of the argument is about I would suggest there are areas which are suitable, and that's reflected in the emerging local plan and the proposals map, and there are areas where the council consider that it's not appropriate. The appeal site is one of those particular areas.
No, I know that, but in terms of the settlement itself, and there's an issue between us as to whether this is a suitable site or not, which we've agreed is the determinative issue. But if it is a suitable site, this point goes nowhere, does it? Because Sileby is a settlement where the council still thinks it can accommodate further growth. Agreed?
That's reflected in the resolutions to approve the developments that have been approved and being built. Whether there is scope for further development on top of that is another question. Yeah,
just let me try and be more specific. The council is proposing a number of allocations at Sileby in the emerging local plan. The council has promoted a plan it believes is sound, and therefore we can infer that those allocations are thought to be sustainable and appropriate and capable of being accommodated, consistent with Sileby's role within the hierarchy, because it doesn't change. In that context, it can't be any part of your case, can it, that additional growth at this site, which is significantly less than the aggregate of the allocations, would somehow be out of kilter with Sileby's role in the hierarchy? That can't be any part of your case, can it?
As I said, as a determinative issue, no, but I do think it's significant background information to this. And as I said already, is there a judgment as to when Sileby exceeds the limit where it isn't sustainable? I don't know don't know the answer to that, but there is as you'll be aware, there's a robust even process for allocation of sites. We'll all be aware that this site was one that was put forward to be allocated in the local plan, but for the reasons that we discussed previously, wasn't put forward. I think the key reason for refusal in terms of development on this area of local separation stands.
Right, let's just put some figures on this if there is an issue about this in all seriousness. Page 13 of the Statement of Common Ground, if you will, please, Mr. Gould. Core document 10.3.
Page 13, you say?
Page 13.
Yep.
We can see paragraph 48 that the draft plan again identifies Sileby as a service centre. It's agreed that the plan proposes the delivery of at least an additional 2,747 dwellings across the service centres. That's the draft plan, equating to an increase in 14%. And paragraph 49, it's agreed the draft plan makes provision for an extra 345 dwellings across Sileby across 6 sites, 3 of which are on greenfield land beyond the settlement boundary. It cannot be your client's position, can it, that Sileby is not capable of accommodating additional growth on appropriate sites. Agreed?
Agreed.
Good. And indeed, in terms of scale of development, you can see that the next sentence, the largest is an allocation of Barnard's Drive for 2 to 8 dwellings. Just pausing there, that's about 34% larger than the appeal site, isn't it, in terms of the extent of development?
I can't do the mental arithmetic, but that sounds about right.
Yeah. So a development of this scale in this settlement cannot be considered by your client to give rise necessarily to an issue in terms of CS1, can it, in that context? Logically.
In that context, I'd accept that argument.
Yeah, okay, good stuff. Let's turn to the more knotty issue, if we can, of CS11. Just turn back a page or two, forgive me. CS11, which is page 69 of the PDF. A question that I really don't know the answer to, and I suspect, Mr. Gould, you won't be able to help me. We know that the last part of CS11 deals with the development management approach that's to be taken in relation to areas of local separation, and that duplicates the development management role of CT4, but doesn't do so using an identical approach. Why on earth does CT4 continue to have a development management role in parallel with CS11? Why wasn't CT4 trumped?
Yeah. So I think I'd answer that in the way that the policy evolves. So the CT4, and in fact, the area of local separation is a policy that's been in the various forms of the development plan for 25 plus years. But that's not to say that it's kept the same form and wording as originally submitted in, I think it was a structure plan in the late 80s. So it's an important policy. It's an important, the area of local separation is very important, and that's evolved and been updated over time. And that's reflected in the emerging local plan where it's taken forward.
Well, let's just drill into CS11 a little bit further, if I may, and then I'll come to the big point in a moment. So CS11 tells us there's going to be support and protection of the character of the landscape area and countryside, more akin to MPPF, we can see. And then we've got first bullet point is protecting character by taking account of relevant LCAs. Then the next is mitigating impact on tranquility, and then requiring development to maintain separate identities of towns and villages. Now, that's not an area of separation issue of itself, but it plainly overlaps with areas of separation, doesn't it?
Yeah, they're not mutually exclusive, but yes, I agree.
Yeah. And we've also got then supporting rural economies, supporting provision of community services, and also supporting rural communities by allowing housing development for local needs. So we've got the positive side of development tucked away in this policy as well. And then we've got the development management approach. We will protect the predominantly open and development character of the AOLS, unless the new development clearly maintains the separation between the built areas of these settlements. It's a one policy, it's a one criterion policy rather than the previous two criteria policy, and it's a policy which plainly requires a judgment, isn't it?
Yes, I think that's reflected in the discussions we've had previously on the tilted balance. But yes, it's a judgment call. Now,
you very helpfully told me that you're not taking a black letter approach to CT4. You're saying that requires a judgment as well. Let me see if we can get some amity on this. If the inspector concludes that the proposed development meets the third criterion here, so maintains the separate identities of the towns and villages, and meets the last part of the policy, i.e. protects predominantly open land and maintains the separation between the built-up areas of the settlement, if he concludes that, he would plainly, this scheme would pass CS11. You wouldn't raise CT4 then as somehow a residual concern, would you?
If that's the decision the inspector takes, and then clearly we have a differing view on that.
Of course.
If third bullet point and the last, as you call it, development management paragraph at the bottom is accepted or rather deemed acceptable in terms of CS11, then I don't see the logic in, because CT4 effectively informs CS11, so no.
Yeah, it's CS11. If we breach that, then we've got problems in that regard. If we don't breach that, then you're not raising if we do, you're not then raising CT4. That's helpful. The only reason I raised that is that EV3 of the emerging local plan seems to revert back to CT4 rather than the CS11 point. But we agree we give that limited weight, don't we?
We agree. We're not in that context at the moment, I know.
And if you've still got the statement of common ground to hand, the issue as to whether there is a breach of CS11 in relation to the area of local separation is the judgment call between Messrs Hickson and Cook, isn't it?
Yeah, sorry, what page is that on? In the
page 12.
Yes.
Good, thank you. Statement of common ground. Sorry, I don't need the statement of common ground. I can do it without the statement of common ground. Presumption in favour of sustainable development. We agree is engaged. And that can be engaged by one of a couple of routes in this case, whether the inspector thinks that the policies in the basket are out of date, and we've agreed some of them are, or via the 5-year land supply, but either way it's engaged, isn't it?
Correct.
Thank you. And putting it in layman's terms, that means that you should be granting permission in those circumstances unless there's a good reason not to.
Yeah, that's clear in the officer's report, and that's clear in my, well, hopefully clear in my proof.
Yeah, and the reason that's put forward relates to the issues that are the two principal issues you talked about. Right, emerging local plan. Can we take up the statement of common ground, see if we can do it using this document and do it relatively quickly? We've already agreed, and it's paragraph 50 if you want the notes, that limited weights to be afforded to the emerging local plan. Let's see if we can agree why limited weight is to be afforded to the local plan, the emerging local plan. We are at a point where the inspectors haven't started the detail of their examination yet. Agreed?
Agreed, yeah.
We don't have the detailed questions from the inspector. We don't have the complete evidence base, and we certainly haven't started the hearing sessions yet, have we?
No, the hearing sessions are scheduled, as you've seen, but no.
Thank you. It is a plan which has a degree of controversy, doesn't it?
In what respect?
Oh, come on, you can give me a general view, Mr. Gould. Are you involved in it?
I'm not involved in the production of them in any way, shape or form, actually. Is it? I suppose inevitably in the current climate, any new local plan is going to have an element of controversy. OK. There are particular concerns, are there not, about the distribution in relation to development towards Shepshed rather than Loughborough? There are infrastructure concerns, and there are some heavyweight objectors that are schlepping up to the examination. Is that fair? I don't know the detail, but I'm aware of sort of the broad level concerns that you've mentioned, yes.
Yeah. So it's not just detailed sites coming forward of we prefer this site and our site's better than your site type argument. There are real concerns which go to the heart of the strategy of the plan, aren't there? Whether
they go to the heart of the strategy of the plan, I couldn't comment. Okay. But in my experience, that's not unusual to have those sorts of concerns, those representations, those objections to be met and to be discussed at the examination public at the hearing sessions.
And as my learned friend and I well know, he having advised Northwest Leicestershire, I advising Leicestershire, but are both of us practicing in this particular county from time to time. There is a big elephant in the room when it comes to local planning in Leicestershire, isn't there? Which is meeting Leicester's needs. Yes, that's again, I'm no expert on the emerging local plan, but that's countered and responded to in the emerging local plans, I understand it. Yeah, and the the crystallisation of what needs would emerge from Leicester hasn't yet crystallised, but we're told it will do imminently as to what districts around Leicester will need to take. Is that something you're aware of, Mr. Gould?
I'm not aware of the detail on that. I'm aware that discussions have been are being had, or rather have been had for quite some time now. If that's close to a resolution and crystallising, as you would say, I don't know the answer to that.
But the one thing this plan doesn't do is it doesn't grapple with that issue, does it? In other words, does it take any of Leicester's housing supply? Again, I don't know the answer to that. Okay. Not to worry, I'll ask my witness in relation to that. In any event, let's assume that there are a number of issues which afford scrutiny. Your assessment is, at the point we are now, with an incomplete evidence base, with some of the inspector's questions, preliminary questions yet to be fully answered, but before we get the inspector's detailed questions, and before we start the hearing sessions, you're confident that we will get a plan adopted within a year. That's your view that you expressed to my learned friend. Do you want to reflect upon that before I spend any time on that, Mr. Gould?
I don't know why I said confident, but I'm more optimistic with that projection than the projection put forward at the moment for adoption in December and January. Yeah.
Well, I think the idea of adoption in December and January is fanciful, notwithstanding that that's in the LDS. Would it be fair to say, and you used the term guess to my learned friend when you gave the answer, would it be fair to say that you would have to be rather optimistic to think that you could complete the hearing examination, the main modifications, the consultation on the main mods, and also get an adoption by this time next year? That would be an optimistic scenario, wouldn't it?
I think it's achievable. It's the purpose of the hearings is it focuses the opinion. The debate is, in my mind, is foreshortened after that, and the conclusion is the same. So that's achievable. I would say it's tight.
Yeah. I may be optimistic that when I told my son when he left this morning to tidy his room, that it's achievable that he could have done so before he left. But it's an optimistic view to think that there won't be clothes still sitting on the floor. So you've chosen to answer an optimistic question with an achievability answer. So I'm going to grapple with my question, I'm afraid. It is an optimistic approach to suggest that there would be adoption within a year, isn't it?
So there's a difference of opinion then as to whether we think that's achievable or not. I do think it's achievable. Whether that's optimistic, I'll leave that for others to decide.
Well, I'm not leaving, I'm afraid. There is a range of reasonable opinion that could be formed in the light of that circumstances as to when the adoption would be achievable realistically. You're at the start of the range at best, aren't you, Mr. Gould? But a reasonable view could be formed that it could be significantly later than the summer of next year. That would be a reasonable view, wouldn't it?
The other side of the coin is that it could be earlier, again, which is what is being said in the programme. I think that's about right, is my opinion.
It's about right in your view. So you're happy that your professional judgment is characterised by my closing by saying, in all those circumstances, a plan that you don't know the level of objection to, you don't know whether there are strategic objections in relation to it, you haven't familiarised yourself with the issue in terms of how it's going to deal with the overspill from Leicester. The fact you don't know these fundamental elements, nonetheless, you're able to sit there confidently and say, no, that's the realistic answer as to when it's going to be adopted. Do you really want me to characterise your professional opinion in the light of that's a realistic answer, Mr. Gould?
What I've been giving is an estimate. So
estimate.
It's not set in stone. Given an estimate, there may well be some flux either way on that. As my experience, yes, these matters will be brought to the fore and discussed in full at the hearings in June and I think in July.
Well, I'll put it once more. Given the lack of knowledge that you have in respect of some of those elements, and given the timescale you've put forward, would it be fair to say you've put forward a best case estimate?
I put forward, yeah, that's a fair argument, yeah.
Yeah, okay. So a realistic view or an alternative view would not be unreasonable, that it could be later. Is that fair?
Logic would dictate that, yes.
Good, thank you. That's helpful. Good. Let's pick up some other points from the statement of common ground. Paragraph 94 next, please. Under the planning balance, it said that there is a disagreement as to whether or not the proposals comprise sustainable development. Now, my understanding is that there's not a locational sustainability argument, given what's agreed at paragraphs 53 to 55 of this document under accessibility. Is that right?
We're agreeing, yes, we're agreeing with the location, with the proximity to services, etc. So yeah.
Yeah. Your point is about environmental sustainability, given the issues raised between Mr. Hickson and Mr. Cook. Is that the reason for paragraph 94 being an area of disagreement?
Yeah, and there's also the weight I give to the economic arm of that as well. I think you would give more weight to it than perhaps I would.
I wouldn't give any weight. I'm an advocate. It's not my job to give weight. That's the role of the planners. I'm humble in relation to this context. Paragraph 51 next, please. Deliverability.
Right, okay. 51.
51.
Site deliverability, yes.
Yeah. It's a site which is controlled by one of the country's leading house builders. There's no reason at all to think that this is a scheme which wouldn't come forward within 5 years in the event that consent is granted, is there?
As an established house builder with normal build out rates, that's not unachievable. I would put a caveat to that, and I know we're dealing with the outline and the plans are indicative,
Yep.
but nonetheless, there's been a fair amount of assessments based on that indicative plan. If I was the case officer with the reserve matters application with the layout as on the indicative plan, I would have concerns about some of the space about dwellings. My point being that might in turn have impacts on the site delivery.
Yeah, okay, let's take that point. The reason why I even raise this is the wording that's been agreed. It's further agreed on this basis the proposed development could make a significant contribution. Even if you're right that there is some toing and froing in terms of reserve matters, it's fair to say that the scheme is largely likely to come forward within the 5-year period, isn't it? Even if there is toing and froing.
Yeah, I agree.
Yeah, so the answer to that is that it would make a significant contribution. The issue is how much of a significant contribution. Is that your point?
It is, yes.
Yeah, okay, good. Thank you, that's helpful. Housing need next, paragraph 89. Tells us, paragraph 89, first bullet point, that the proposal lies in a location where there is an identified need for market housing and the council's unable to meet the 5-year land supply. You gave us the figure, sorry, you gave us the weighting of significant weight. Now, the reason why I'm going to ask this question is just to understand your range. It's not a criticism at all, Mr. Gould. You've given us 3 different words for how a range of weighting applies, one of which is limited, one of which is moderate, one of which is significant. I assume that those are in rising order of the degree of weight. Is that fair?
Correct.
Yeah. So by significant, you're saying more than moderate.
Correct.
Yeah, good. I only raised that because obviously the antonym of significant is insignificant, and you're not saying that's how you're using the word. You're using it in that scale that's more familiar. Agreed?
Agreed, understood. I mean, it's an important need. Yeah, all things being equal, and clearly if this is allowed, then that is an important benefit, which I said at the beginning.
Okay, paragraphs, that's helpful. Thank you very much. I won't task you as to whether that's equivalent to substantial or not. The inspector can form his own view. We're in the top end of that that range. I get that. Paragraph 66, affordable housing. We can see there, can we not, that paragraph 66, that the needs assessment has risen from 392 per annum in 2017 to 476 per annum by September 2020, can't we?
Yes, I'd agree.
And we also know from policy CS3 of the core strategy that at the time of the adoption, so we're taking it back to 2015, that the figure was an anticipated 180 per annum. Agreed?
Yes. Yes.
So we are in a district where there is an increasing need for affordable housing over the last decade. Agreed?
Agreed. I don't think that's unique to Charnwood, but yes, agreed.
No, I'm not suggesting for one moment it is. But the context is firstly that there is a rising need for affordable housing, which is real people in unmet need, to which the 51 units from this scheme would assist in terms of resolving. Agreed?
Yeah, again, that was one of the benefits I listed at the beginning.
And if we go back to paragraph 89, we know that there is agreement that the position in Charnwood is worse than the regional position, isn't it?
That is the case.
And both those factors, rising need and comparison to the regional position, both increase the weight to be afforded to the provision of affordable housing. Do you agree?
I agree. It's an important benefit.
Yeah, that wasn't my question.
I know.
When the inspector, you should play rugby league. You're very good at sidestepping. When assessing weight, the fact that we are in a district with a rising need over the last 7 years, and that we are worse than the regional position, adds to the weighting to be given to this benefit, doesn't it?
I understand the argument, and yes, I agree.
Yeah. Good, thank you. Next, biodiversity, net gain and habitat creation. You've told me that's moderate weight. I understand that. But if I can just take you across to paragraph 93, if I will, please. Just to make sure I've understood what your answer was to my learned friend. Paragraph 93 sets out 4 different items which are said to be areas of disagreement as to whether they are benefits of the proposal. And the first of which is publicly accessible green infrastructure for existing residents. Now, you told my learned friend that's actually something to which you give moderate weight.
Mm-hmm.
So should that be in the area of disagreement or in the area of agreement then?
I think it can be both, because biodiversity enhancement, biodiversity net gain, and public open space don't necessarily have to be the same thing. In fact, there's an argument to say that they could be one might impact on the other. I think so going back to, was it 68? Did you say?
Yeah, ecology is 85, etc. I'm banking the issue that you're telling me we get moderate weight for biodiversity, net gain, and habitat creation, and I was trying to nudge you into the notion of the fact that the large area of open space that's been provided, which will be available to not only the residents of the new development, but also existing residents of the 2 settlements. That's a benefit of the scheme. It may be that the cost is too high from the council's perspective, but I understood your answer to my learned friend to say, yes, I agree that that's a benefit. I give it moderate weight. In which case, shouldn't it be in the paragraph 89, not 93, is my question.
Understood. Right. I think the reason it's in 89 is I think there still is a little bit of work to be done on the biodiversity and exactly the metric that's being used and exactly what will be where. And then it is a benefit.
Right. Good.
But it's again a difference of opinion with Mr. Hickson and Mr. Cook as to the landscape quality and the visual impact of that new piece of ground to the bottom of the site.
Right. OK, so the degree of the benefit is an issue between the parties, but it's agreed to be a benefit.
That's a fair point.
And it's presumably the same point in relation to the second bullet point. The opportunity to increase planting to better reflect the characteristics of the wider landscape, there's an issue in terms of the degree of whether that's the case or not, but that you're not saying that taking account of an opportunity to better reflect characteristics of the wider landscape is not a benefit. You're not arguing that, are you?
No, or in other words, if there's a, as a planner, you're never going to have issues with sort of further planting enhancement, exactly like that. But it's about the exact detail of that and the quality of that, and whether it's a native species, whether it's indigenous, etc., and how it sits in the landscape. So there's some detail to be done.
And putting on your putative development management hat on, the next bullet point, I know you said that's a matter for Mr. Higson, but if development does come forward on the site, our position is that the current development edge is a little brutal, as it were, a little stark, a little unremitting. Is that a fair assessment that the inspector will have seen on site?
Oh, well, clearly the inspector makes their mind up on that. In my opinion, it's not out of the ordinary.
No. But softening the edge to developments to provide a better interface between the undeveloped part or the undeveloped land that lies alongside settlements and the built part of settlements is something that's been familiar to you in your 20 years of practice, I assume, Mr. Gould.
It is, but whether you can use that as part justification for this development to soften that boundary there, I wouldn't agree with.
Well, I'm not suggesting that does it. I'm not suggesting that that's a justification in its own right. All I'm saying is that contrast position future with position existing, you could achieve a better edge to the settlement by softening it. That's self-evident, isn't it?
I do understand the argument. I don't have a problem with the boundary as is. If that was an issue, there's certainly some quite simple work that could be done to soften that. My point is that as a justification, a bonus then, if you like, a benefit to the development is that boundary will be softened is not something I would support.
No, but I'm talking about something slightly different. I'm not talking about justification for the development. I'm talking a benefit of the development, which is a factor which weighs in the planning balance. But anyway, I've probably spent more than enough time in relation to what is a relatively small part of the case anyway. And the final bullet point under 93, which my learned friend and you agreed is essentially a point that's encompassed by the previous versions. And my learned friend said, well, it's a double counting point. If you go back to paragraph 89, we are agreed, are we not, that what's proposed is the provision of market housing in an accessible location?
Yeah, agreed. And it's the previous paragraphs to it as well. I can't remember, it's in the 50s, but yes.
Yeah. So if one were to put a line through, mentally put a line through that last criterion, but add accessible location to the first bullet point of 89, that mirrors the position between the parties, doesn't it?
Yep.
So subject to your point about the designed edge of the settlement, looking at paragraph 93, we agree that those other elements are benefits. It's just how you describe them.
That's exactly the point, yes.
Good, thank you. And in terms of the weighting to be given to economic benefits, the inspector will make what he will of your conclusion as to the benefits which arise. But you're not saying that bullet point is wrongly fitted in 89 as a benefit, are you?
In terms of no, there will be economic benefit associated with that, investment, etc. It's the level of that.
And then in deference to the Smiths, I'm going to ask you, what difference does it make? Because if Mr. Cook is right in his conclusion, we're agreed permission should be granted irrespective of the weighting to be given to these additional benefits. And if Mr. Higson is right, your conclusion is it should be dismissed even if we're right about the weighting to be given to these benefits. Is that fair?
You're going to have to repeat that again, sorry.
By all means. This is what difference does this fascinating debate about the weight to be given to benefits make to the overall conclusions of the inspector?
It's exactly the tilted balance. It's that argument. It's whether it levels off the, for want of a better description, the seesaw, or whether it tips it one way or the other.
Yeah. And on the seesaw, we've got the benefits which add on one side and the harms which add on the other, but it's a tilted balance, as is all familiar territory. But your case is that the significant adverse effects outweigh the benefits in any event.
Correct.
Irrespective of the weight difference in weighting between us, and our case is that the harms come nowhere near outweighing the tilted balance, including when the benefits are on there.
Okay.
So the issue between us, the determinative issue, really is the effect of the adverse impacts upon the AOLS and the countryside. This is a bit of a sideshow, isn't it?
I will answer your question, but that's pretty much what I said at the beginning. And is planning the sideshow to this? No, it's the core part of it. But the landscape argument, the area of local separation, is the key part to that planning argument.
Okay, that's understood. I'm taking that as a yes, Mr. Gould. Thank you very much indeed for your time. Unless something comes up on the WhatsApp that tells me that I've missed out something dramatic in the next 30 seconds, sir, if you'll just forgive me, then sir, that completes my cross-examination.
Thank you. Mr. Tucker, I was going to ask whether you were going to cover the neighbourhood plan policies, because I couldn't recall whether you said you were going to go to them or not. But
no, sir, I think in the light of the answers that I got, I don't need to.
Okay, fine. Thank you for that.
Particularly since paragraph 14 isn't engaged, which is a concession that was made properly in examination in chief. So I don't need to take the witness there.
Thank you. I was just checking in case that had been missed. I don't have any questions for Mr. Gould. Does any? Well, I don't think there are any interested parties present who support the scheme. Therefore, I'm not expecting any interested parties to have questions for Mr. Gould. So if that's the case, then Mr. Richards, would you like to begin your re-examination of Mr. Gould?
Yes, sir, and I won't be very long.
Okay.
But Mr. Gould, just one or two matters. We could usefully start, I think, please, back in the core strategy and policy CS1, which you'll find in old money on page 30 and in new money on page 31 and 32 of the PDF.
Yep.
And you were looking on the second page of the text of that policy at the policy for service centres, about a third of the way down that second page.
Yes.
And you noted with Mr. Tucker the strategy was to plan positively.
Yep.
And that there were three bullet points that would provide indicators of positive planning.
Yes.
And I think you've told us that, well, you better just confirm, have the stakeholders in the borough in respect of that first bullet point managed to achieve the positive outcome of at least 3,000 new dwellings?
That is the case, yes.
Yeah. Now, you've agreed it's not a ceiling.
Yes.
But what's your judgment, please, as to how the achievement of 4,400 new homes by this stage of the plan period to 2028, what's your judgment as to how well that's been met?
Well, it's been exceeded. I think in my proof of evidence, I talk about the number of houses that have been built in Sileby and approved, and proportionally, Sileby is taking up from memory, I think it's 20%, 20-something percent on when compared to the uplift in other service centres.
Okay. Now, you were also asked some questions about the third bullet point.
Yep.
Responding positively to sustainable development. Now we know that the presumption in favour of sustainable development is engaged in this case, paragraph 11 of the NPPF.
Yes.
And if the inspector decides that the adverse impacts do significantly and demonstrably outweigh the benefits, if the inspector decides that, will the development amount to sustainable development?
Well, the answer would have to be no.
Yeah. And if the answer to that question is no, under the third policy of CS1, would the appeal scheme be something that CS1 required a positive response to?
No, because it's, following that logic, it's not sustainable development.
Yeah. In those circumstances, how would you characterise permitting the? I'm getting an echo now.
Same.
And I think Mr. Tucker's fault because his blue screen, that's it, he's cured it by turning himself off.
Means I now know how to put off my loner friend, which is the first time in 20 years.
In those circumstances, then, when the inspector decides that it's not a positive response and it's not sustainable development, my loner friend Mr. Tucker asked you, well, where would there be a breach of CS1? If the inspector reaches those conclusions, would it be fair to or not to characterise that state of affairs as a breach of CS1?
Again, following that argument, then yeah, in terms of it would not be sustainable.
All right. Then can we go, please, to CS11, which is page 69 in new money and page 68 of the hard copy.
Yeah.
And you went to the development management policy at the end of the list of bullet points. We will protect, etc.
Yep.
And we can read there, if we were reading this for the very first time, we note that what is to be protected is the predominantly open and undeveloped character of something called an area of local separation.
Agreed, yes.
Now, I think it's common ground between us that the core strategy itself doesn't define where these areas of local separation are. Where do we need to go in the adopted development plan in order to understand what these areas of local separation are that the core strategy is referring to?
CT4.
Yeah, okay. And then if we want to see that, once we've been to CT4, and I don't invite you to turn it up, it's not controversial. We then have to look at a policies map to see where the CT4 designation applies.
Correct.
Yeah, okay. Mr. Tucker was wondering what CT4 added to the price of fish upon the adoption of CS11. Does it at least enable the reader of CS11 to identify where these areas of separation are?
It does exactly that, yes. And
yeah, and that might explain, we can only postulate, why CT4 was saved.
Correct.
Now, if there is a difference in development management approach in policy CS11 to that in CT4, so that the policies are pulling in different directions, then I think you agreed with Mr. Tucker that the later in time adopted should prevail.
Correct, agreed.
Yeah,
yes.
you were very wise to do so, because that's precisely what section 38.5 of the 2004 Act tells you to do. But the inspector will already know that, I'm sure. And then the last question I want to ask you about is the limits of development. You agreed with Mr. Tucker that the limits of development set in the 2004 local plan, mine says that you agreed with his suggestion that they were of some vintage and based on an out-of-date needs assessment.
Agreed, yes.
And then in chief, we looked at the limits of development set by the neighbourhood plan, the Sileby neighbourhood plan. Do you recall that?
Yes.
Yeah. So if the inspector wants to know what the most up-to-date depiction of the limits of development is in the adopted development plan, should he go to the neighbourhood plan or should he go to the 2004 local plan?
The neighbourhood plan, that's the most up to date.
Okay, I think that's what you were accepting, but I just wanted to make it sure. And so far as the adopted neighbourhood plan is concerned, can we just look at what it said about limits of development? And it's CD 6.13. And page
22.
Yes, policy G1 was the limits of development. Just go back to page, policy G1 on page 22 is the policy, but just go back to page 21 for a bit of an explanation.
Yes.
Limits to development have been determined using the following criteria. Development sites with an extant planning permission as at 1 July 2018. Yeah.
Yeah.
Proposed residential site allocations with the neighbourhood plan. Well, that's
that.
So that was the position there. My question is this: did the neighbourhood plan take into account anything that was going to be brought forward in what is now the emerging local plan?
You can lead on that, Mr. Richards.
Yeah, it didn't, did it? It confined itself. It confined itself to the situation as it was in 2018.
That's where I was going to go with it, but I was just checking the next map. Yes.
Yeah. Okay. Good. Now I just want to get the agreed baseline so that the inspector doesn't fall into any error on that account. Thank you very much, Mr. Gould. But I will follow Millennium Friends' lead and just check that my WhatsApp group hasn't lit up. No, that's fine. Thank you very much, sir.
Thank you, Mr. Richards, and thank you, Mr. Gould, for your contributions today.
Thank you, sir.
Thank you. So that brings to a close the council's planning witness, and so we have the appellant's planning witness to come next. And in terms of timescales, looking at where we are, I was going to propose breaking for lunch slightly earlier. Mindful that I think the time estimate for Ms. Medley's evidence is chief is about 45 minutes. Is that right, Mr. Tucker?
I think it may be an hour, sir, but no more than that.
Probably more, then I think it probably makes more sense to start afresh after lunch rather than break it with a lunch break. So we can do that, and then I think probably there's no merit in starting cross-examination today unless the advocates have a strong view on that.
I prefer to do it in one hit.
Fine. Okay, that's fine. Well, in which case we'll adjourn for lunch. Are we happy to make it slightly shorter? Come back at 1:30? Would that be reasonable for everybody?
Well, yes, it means that we've got a sporting chance of then adjourning at 2:30.
Yes.
So I would, if possible, because I just need to run an errand which is unavoidable. Would, if possible, prefer an hour, if that's okay.
Okay, no, that's fine. I'm easy on that. So we can say 1:40. So an hour's from now is fine with it. Yeah, that's okay. Great. Thank you. Unless there's anything else from anyone before we adjourn, we'll adjourn for lunch and come back at 1:40. Thank you.
Thank you, sir.
Thank you, sir.
Hello everyone, it's 1:40 and the inquiry is resumed. Are we happy to go straight on to Miss Medley's evidence in chief, or are there any procedural points before we do?
No procedural points from me, sir, apart from to ensure that Miss Medley is actually on the call. Yes, she is. Yes.
Yes. Oh, yes, I can see. Hello, Miss Medley.
Hi.
Anything from the council, Mr. Richards?
No, sir. I'm quite. I can raise any matters at the end of the day when we discuss about where we're going from here.
Fine, that's great. Okay, well, if there's nothing else from anyone, then Mr. Tucker, would you like to introduce your witness, please?
Thank you, sir. And I think Ms. Smedley has sent through to the case officer at the start of lunchtime the list of documents that she may refer to in examination in chief.
Yes, thank you. I have that.
Thank you, sir. Ms. Smedley, you've produced a main proof of evidence, a summary proof and internally bound appendices. Can I ask you to turn to page 1 of your main proof, if you would, please?
Yes.
Can you confirm that you are insulated from social media, other distractions, people handing you notes, etc.?
I am. I'm sat alone.
Good. And you've turned the WhatsApp off is the most important question. Good stuff. Are you Angela Smedley? First question.
I am.
Good. Are you a chartered town planner and associate director at Fisher German, based in Ashby de la Zouch? Do you hold a Bachelor of Arts degree with honours and a postgraduate diploma in town planning from the University of Nottingham? Are you a member of the RTPI?
Yes, I am.
Thank you. You tell us at 1.4 about your decade and a half of experience, just over a decade and a half of experience, the last 8 years of which have been at your current firm across a wide range of projects. Is that right?
That's correct.
You also tell us at 1.5 that you are familiar with the site and the details of the case. Can I ask you to read, please, from I understand my duty to the inquiry?
Yes, I understand my duty to the inquiry and have complied and will continue to comply with that duty. I confirm that this evidence identifies all facts which I regard as being relevant to the opinion that I've expressed, and that the inquiry's attention has been drawn to any matter which would affect the validity of that opinion. I believe that the facts stated within this proof are true and comprise my true professional opinions which are expressed irrespective of whom I am instructed.
Thank you very much indeed. In common with the other witnesses, sir, I just intend to ask Ms. Smedley additional questions rather than read out the summary, if that's acceptable. Thank you, sir. Ms. Smedley, can you just start off with some matters that are agreed, and I think we can say they're definitely agreed now in the light of this morning. The local plan and the core strategy are more than 5 years old, and the authority is unable to deliver more than a 3.34 year supply of housing. Now, we're told that tomorrow there will be confirmation that 1 year further on, that it will still be able to demonstrate no more than 3.3 years supply of housing. What observations, if any, do you make in relation to that point in the light of their current failure to prove a 5-year land supply?
Well, it's surprising, really. I would have hoped that they would have been able to increase that supply, especially given the SUEs, and one would have thought a year on that some of the delivery might have taken place or was going to be coming on stream in a further monitoring year. But obviously still at 3.3 years, there's obviously no movement, not even a little movement.
Thank you. So does the fact that the council still remain at about 3.3 years supply of housing as of Friday, forgive me, does that add to, detract from, or is neutral in relation to the outcome of this appeal and the benefits which arise from the proposed development?
I would say it's exactly the same, so neutral.
Thank you. In relation to issues of harm, can we turn first of all to policy CS1 of the core strategy, if you have that to hand?
Yes.
Which I think is core document 6.03.
Yes.
And can we turn to policy CS1, which I have starting on page 31?
Yes.
Now, first of all, in relation to the first aspect, the highest tier of development to meet the at least 13,940 homes between 2011 and 2028, we've got a series of sustainable urban extensions close to Leicester, and then we've got urban extensions close to Loughborough, and then Shepshed, the 2 largest settlements in the district. How's the authority getting on with those?
Well, not very well. I understand that 2 of the 3 sustainable urban extensions have commenced. They've been implemented, but to date, no dwellings have been delivered. The core strategy trajectory anticipated that over 2,000 dwellings, about 2,250 dwellings should have been delivered by now to the 2021 monitoring year. So none of those have been delivered.
So you gave us a figure as to how many were meant to have been delivered. Could you just give that again, because I think it just slightly broke up for me?
Sure, it's 2,245.
Thank you. Now, a point has been made by the council that if one moves further down CS1, the minimum of 3,000 units within the 7 service centres has been exceeded by around 45%. Firstly, given that there's been no delivery of the higher tier SUEs, do you have any observations about the delivery at the service centres? And then secondly, does that give rise to any concerns?
No, I mean, clearly, if there's been no delivery on those SUEs, the core strategy has failed, but they haven't got their supply. So moving down the hierarchy, yes, they have already met that 3,000 dwelling minimum, but that does not mean that you couldn't go beyond that, a point that Mr. Gould acknowledged and accepted. There's no cap on housing numbers within the service centres. And it's not a new factor either, sorry, delivery at the point of adoption of the core strategy, that figure had already been exceeded.
The 3,000 figure?
Yes.
Thank you. And in terms, we know that the emerging local plan has additional allocations being directed towards the service centres. Do you have any observations about the proposition about the extent to which Sileby can accommodate further growth?
Yes, of course. I mean, one of the allegations is that Sileby has already had a disproportionate amount of growth, but moving forward, the emerging local plan is looking to allocate a further 345 dwellings to Sileby.
Can you turn to paragraph 4.19 of the core strategy, please, which is on page 23 of the PDF?
Yeah. 4.19. Yes.
And we can see from the last sentence that the service centres are not suitable for sustainable urban extensions, but there's a view provided there in terms of the level of services at service centres. Do you see that?
Yes.
And then if you just scroll a little further on, please, to paragraph 4.43.
Yes.
Which sets out what each of the service centres has. And we also know from the statement of common ground what Sileby has. What are your observations about the level of services within Sileby and its ability to accommodate the proposed development?
Sure. There are a number of facilities listed in that 4.43. Sileby ticks all of these boxes and more. I would say that, in fact, if you turn to the council's settlement hierarchy assessment, which is CD 611.
Okay, well, let's just wait to catch up with that. So that's CD 611.
I'm turning to figure 10, which is on PDF page 24.
This is normally the point at which I tell a witness to keep their eye on the inspector's pen, but we can't do that anymore. So page 24.
Yeah, on PDF page 24. And you'll note from that table, that assessment, assess the relative sustainability of all the settlements within Charnwood, and you'll see that it scores Sileby the same as the urban areas above it of Loughborough, Shepshed, Thurmaston and Birstall.
So we're looking at the final column, are we?
Yes, of 11 points in that total column, in the final column.
And if the inspector wants to see more granularity, then we can work back in terms of the other columns, can we? So, for example, employment access and higher order service access, etc.
Absolutely, yeah. That's just the summary table.
Now, we know it's not a reason for refusal, but what's your overall view about the ability of Sileby to accommodate a development of the scale proposed?
Well, clearly it's one of the most sustainable settlements within Charnwood as an overall, and it looking forwards, it should be able to accommodate more growth.
Thank you. Now, I think just moving a little earlier in this document, figures 4 and 5 you wanted to draw attention to as well?
Yes.
Tell the inspector what you want to draw from those.
So figure 4, which is on PDF page 10, and the following figure number 5, they set out, if you look at the Sileby column, row, should I say, that 9% of residents with work within Sileby itself. There's very strong links in the remaining borough, with 15% of residents working in Loughborough and an overall 44% working within Charnwood. I think you can see that on the sort of first column down, 44% within Charnwood and 21% working in Leicester. My point there also being that there's a good level of public transport provision from Sileby, including regular bus services to Loughborough and Leicester from within 100 metres of the site. These operate half-hourly services during the day and hourly during the evenings, with journey times taking just 25-30 minutes in both directions. I would also say that Sileby benefits from a railway station, which sits on the Midland Main Line, serving a number of villages along the route, as well as Loughborough, Leicester, Nottingham, and other settlements. Hourly services operate to these destinations with a 5 to 10 minute journey into Loughborough, just 15 minutes to Leicester and 35 minutes to Nottingham. So I'd say this easily caters for commuter travel, offering access to a wide range of employment opportunities as well as recreation and leisure.
Thank you. And in relation to the rail station that you draw particular attention to in your proof of evidence, do all of the service centres have railway stations?
They do not. No, of the service centres that there are, it's only Sileby, Barrow upon Soar and Syston that have a train station on the main line. There is a heritage railway station, but that doesn't really offer accessibility to employment and leisure and so on in some of the other service centres. But even Shepshed in the urban area doesn't have a railway station. Therefore, a lot of the residents from service centres of Mount Sorrel, Quorn and Rothley have to rely on the services provided at Sileby.
One final point on CS1, if I may. The inspector can read the figures in CS1 as to how the breakdown of 13,940 is said to be delivered. And we've already looked at the highest order centres, and we've looked at the service centres about the level of provision. If you go down to the next tier down, so the other settlements, we've got a provision for at least 500 homes. Again, a minimum figure. Yes, so in terms of the likely or the intended strategy, what observations do you make about the comparative position of service centres in the overall hierarchy in the delivery of housing?
Well, clearly the strategy is to focus growth onto the urban areas, but very much importantly to deliver growth to the 7 service centres as well. It's clear that those service centres and Sileby in particular, their role extends than just be providing for those within their own settlement, but it plays a much more important role to the residents of the wider areas, including the other settlements and the small villages and hamlets.
So do you take a view as to whether there is a conflict with CS1 therefore?
No, I do not.
Is that you don't take a view or that it's not breached?
Sorry, I do take a view. I believe that there's no conflict with CS1.
Thank you. And in terms of the provision of general market housing in the context of there not being a 5-year land supply, what observations do you make as to weight to be afforded to that? And I'm going to come to the emerging plan in a moment.
Weight to be afforded to the provision of market housing.
Where there isn't. Thank you. Affordable housing. What's your position on affordable housing?
With regards to affordable housing, what we heard earlier today, that the core strategy was seeking to provide 180 affordable homes a year. That has increased now to 476 dwellings per annum in the 2020 housing need assessment. So that's the most recent data we have. So there's a significant increase there. So our appeal scheme will deliver 30% affordable homes in accordance with the current policy CS3. That's 51 affordable homes, and I believe this should be afforded significant weight.
We discussed this morning about the fact that affordable housing need is increased or has increased over the last few years, and also that Charnwood has a higher than average affordable need compared to other authorities within the East Midlands. Does that add to, diminish, or leave untouched the weight to be afforded to the provision of affordable housing?
Add to it. Clearly, Charnwood has a higher affordable housing need, and delivery of this scheme would help to meet that need.
Thank you. Next, settlement limits. Policy ST2 of the adopted local plan, which I don't invite you to take up in the light of this morning, identifies the limits of built development back in 2004, which are agreed to be out of date based upon an out of date development need.
Yes.
Could you take up then, please, CD 6.13, which is the Sileby neighbourhood plan, and just picking up a point raised in re-examination?
Yes.
The red line that we find on page 23 is what I want you to look at, please.
Yes.
In terms of the derivation of this red line, Malone Friends witness indicated that the white land, which is shown within the red edge, reflects permissions that have been granted.
Yes.
Okay. The remainder of the red edge, is that the same as or different to the 2004 local plan?
That's the same as the 2004 local plan, limits to development. This neighbourhood plan essentially rolls those limits to development forward, but includes the planning permissions that have been granted since that date.
So to what extent, save for the rolling forward of boundaries to take account of the granted planning permissions, to what extent are these boundaries more up to date than the 2004 boundaries, in the sense of based upon an up-to-date review of needs?
They're not based on an up-to-date review of needs. They literally are just rolling over the 2004 boundaries of the out-of-date needs and just include the planning permissions as they are.
And we know that the boundaries don't include the emerging allocations for the local plan, which are based upon the local housing needs, as opposed to the core strategy, which is based upon the 2014 HEDNA.
That is correct.
Sorry, 2014, not 2004. I'm so sorry. So help me with this. In terms of the up-to-date needs that are before the inspector, does this boundary reflect the up-to-date needs which have been identified by even the authority?
No, it does not.
Is this an up-to-date settlement boundary plan, therefore?
It is not.
Thank you. And to what extent has the authority been granting consents beyond settlement boundaries in recent years?
There's been a consistent breach of the limits to development, whether they're the ST2. If I can ask you to take up ID4, which is the housing sites plan.
Okay, so that's the housing sites plan. That's glorious green, yellow, beige and grey.
Yeah, the council's plan which was prepared to identify all of the housing sites that have been permitted or with a resolution to grant consent. You'll see from this plan that actually the council allowed a regular breach of ST2 by approving almost all of these sites, including the Seagrove Road sites. I think the majority of those, the Barnard's Drive, which is a resolution, Pease Hill Farm, Millbank Place, and Stanage Road. So those are just the examples where they've allowed a breach of ST2 within Sileby itself. A number of these sites are being relied upon that are outside of the limits to development of Sileby to contribute to the borough's 5-year housing land supply, which actually amounts to 366 dwellings. These limits are simply out of date. And as we've just gone over, the neighbourhood plan limits to a rollover from the extant limits to development and merely add the current planning permissions.
And we know, because we were taken to it this morning, core document 6.05 shows the settlement limits that the authority is promoting the emerging local plan. The corollary of being out of date is that settlement limits are therefore in need of review. Are the settlement limits in the process of being reviewed in this authority?
They are, yes.
Thank you. Has that review completed? Well,
their review has been completed, but the examination has not undergone yet.
All right, fair point to pick me up on that. Has the process of scrutinising the council's review been completed?
It has not.
Thank you. Right. So in relation to any conflict with the settlement boundary policies, neighbourhood plan, 2004 local plan or core strategy, what do you say in relation to that? What weight should the inspector give to conflict with the settlement boundaries?
Limited weight.
Area of local separation, the main event, as it were. Let me see if I can shorten some of these questions. Mr. Gould indicated that the most important policy to consider in relation to settlement boundaries was CS11. Do you agree?
I do, yes.
And it's agreed in the statement of common ground and by Mr. Gould that calls for a judgment about the extent to which there is still the maintenance of separation of settlements, etc. Do you agree?
Yeah, absolutely agree. It's it requires that judgment, yes.
And in terms of the determinative issue, do you agree with Mr. Gould that that's really an issue as to what the inspector makes of the conflict between Mr. Cook and Mr. Higson?
Yes.
I think I described planning as a bit of a sideshow this morning. I'm not going to quite say that's to my own planner, but in relation to that, therefore, is the primary show the issue of the landscape and the AOLS issue
yes.
dealt with by the witnesses. Yeah, thank you very much. That's helpful. Good. Thank you for that. We know that the council has already granted breaches in locations which have been covered by policy CT4 and CS11, Melton Road, etc. What are your thoughts in relation to that? What should the inspector make of that?
It is clearly a case-by-case basis, and a judgment really is to be made.
Good, and I think, sorry,
yeah, just that judgment is to be made on each case.
Thank you. You've identified examples where that's taken place. For example, Rotley, for example, Mount Sorrel, etc. Plainly, the inspector will need to form a view in any given circumstances. What do you invite the inspector in broad overview to make of other instances where consent's been granted within an area of local separation?
Just that that in respect of CT4 and CS11, well, in respect of CT4, that apologies, I've lost my train of thought. That CT4 has an outright ban on housing, and I consider that to be very relevant to the supply of housing, and it is out of date. In respect of CS11, that does require a judgment, and the judgment that Mr. Cook has come to is that the separate identities will be maintained, and there will be the gap maintained, the coalescence will not occur.
Well, let's just try and identify this. I think you drew attention within the notes provided to the inspector about core documents you wish to look at. One of those was core document 7.07, which is the Rothley case. Could you just turn that up, please?
Yeah.
Simple question. Which part of the Rothley case do you want the inspector to consider?
Yeah, bear with me. It's paragraph 8.19, which is on PDF page 51.
Yeah.
Well, it overlaps the pages 51, 52, and in that it sets out, the inspector sets out that policy CT4 is clearly very relevant to the supply of housing. It represents an outright ban on open market housing in the ALS. The effect of it is that it is very relevant to the supply of housing. It also sets out that there will be, it's clearly not the case here in paragraph 40, sorry, I'm just trying to see where I wanted to bring you to. The limits to development and ALS boundaries were drawn in the 2004 local plan, reflecting housing needs up to 2006 only. The end of that was the end of the plan period. The housing needs are obviously greater in 2013, the point of that appeal decision, and the emerging core strategy acknowledges that the ALS boundaries will have to be redrawn as part of the site allocations and development management policies. That document never occurred, but this also serves to demonstrate the direct link between ALS and provision of housing.
So that's an inspector whose views were accepted by the Secretary of State, concluding that if the ALS is a preclusive policy, full stop, that's therefore a relevant policy for the supply of housing under the previous version of MPPF, and points out the extent of need. We know that that's not the position of the authority in this case now, that Mr. Gould indicates that CT4 should be interpreted as requiring a judgment. Do you agree?
I agree, yes.
Yeah, good, thank you. Good. In relation to policy CS11 and the extent of CS11, we know that essentially it's been rolled forward as between the area between Sileby and Cossington. What view do you have about how up to date CS11 is in terms of the AOLS?
I consider that it is not up to date. That is also a policy that is relevant for to the supply of housing. If you turn to the core strategy at CD 603.
Yeah.
Bring that up. At paragraph 7.15, which is, I think, page 67, 68, PDF 68.
Yeah, so this is after 7.14, which sets out where the areas of separation are.
Yeah, 7.15 sets out the retention of areas of local separation will be balanced against the need to provide new development, including new homes in the most sustainable locations.
Next paragraph.
We will also explore opportunities for new areas of separation in those areas previously designated as Green Wedge in the Borough of Charnwood. local plan and in association with strategic developments for homes and jobs.
Okay, so let's just think about that then. That balance between maintenance of AOLS and the need for housing for sites of this nature, assuming that Mr. Cook is right that there is some capacity on the site, and we know that Mr. Higson's also said there was some capacity for housing on the site, to what extent is this designation one that ought to be revisited or not in the emerging local plan?
It should be revisited. There's clearly a balance to be had and housing. We know there's a need to provide homes, so yes, it should be reviewed.
But if you look at policy CS11 itself, page 69, last part of that, the development management part, and also the third criterion, which talks about separate identities. If Mr. Cook is right, is there actually a breach of CS11 by these proposals?
No.
Thank you. The policies of the NDP, the neighbourhood plan, do they add anything to that debate?
No, they do not.
Thank you. Right. Next, if I may, the 106 and the benefits which arise from the appeal proposals. I think if you turn to, firstly, the benefits. So if you can turn to paragraph 830 of your evidence, please. Probably a useful way of looking at it. Yeah. And just mindful of the fact that if one turns to your appendix 1, we've got your judgment about the weight to be afforded and whether there's conflict with particular policies. See that?
Yeah.
So could we just pause for a second? Unfortunately, I think I have too many PDFs opened and they've crashed on me. So you just bear with me a moment to get
this
proof back up on the screen. Yes, if any document sizes weren't quite as massive as I think my computer would cope better. Right. Okay, so sorry, which paragraph were we looking at?
So we're about to turn to paragraph 830 of the proof of evidence, but I was just in passing flagging up that if Ms. Smedley, the inspector, wished to see a summary of your view of the policies which are alleged to be breached and the degree of conflict and the weight to be afforded to those, can he see that in summary in Appendix 1, Table 1 of your evidence?
Sorry, yes, you can.
Yes, good. And if he wants to see your view on those policies which are agreed to be relevant but aren't said to be breached, does he find that in Appendix 2 of your evidence?
That's correct, yes.
Right, good, thank you. That's just topping and tailing the policy bit, that's all. Benefits. Firstly, delivery of market housing. To what extent is this a scheme which is deliverable within the 5-year period?
Well, it's as we discussed earlier, this is Barrett David Wilson Homes, a large nationwide house builder. They're keen to get on site. One of the conditions, I forget the number, it might be number 1, number 2, does have a shorter implementation time of 18 months rather than the 3 years, sorry, for the reserved matters, and 2 years beyond that. And they're keen to get on site. There's no promoter that needs to sell the site. They're available and ready to get on.
You've already told us you give that, as you set out at 8.32, very significant positive weight in your judgment. Is that different from the officer's report to committee as you set out there?
No, they've said significant positive weight.
Thank you. Affordable housing, in the light of the points that we talked about before, what's your judgment in terms of the weighting to be given to affordable housing in those circumstances? I think you set that out at 4.36.
4.36.
Sorry, 8.36. Did I say 4.36?
8.36. Okay, yes. Well, we're providing 51 up to 51 affordable homes, accessible location, contribute to the very significant shortfall that we've already discussed earlier on today, and I afford that very significant weight.
Next, same question as I asked before on general market housing. Is that different from or similar to that of the officer's report?
They've attributed significant positive weight also, yes.
Thank you. Title of 8.38, you have public open space there. Now we know that the area of open space, the 5.88 hectares of open space which is proposed in this instance, is greater than that which is the minimum required for the scale of the proposed development. And we also know from Mr. Gould's evidence that it is a benefit to existing residents that they would have access to that. Could you just explain what weight you give to the provision of that open space and why, please?
Yeah, sure. Whilst the primary purpose of this benefit is, of course, intended to make provision for the residents arising from this development, the significant over provision for the site of this size will help to address existing shortfalls in open space and will also benefit the existing community. And I afford it significant weight.
In the real world, how do you anticipate this area of land will be used? Just exclusively by the people who live on the new development, or by a wider population?
Sure, a wider population, both Sileby and Cossington.
Thank you. Within the 106, there are a variety of contributions in respect of outdoor sports in Sileby. I think it's £56,000. There's enhanced pitches and bowls club, etc., as well as community space. Is that exclusively to the benefit of the new residents, or will that also have benefits to the existing residents?
That will also have benefits to the existing residents. Yes, absolutely.
Thank you. And your overall view in terms of the weight to be given to that is what?
Is significant.
Thank you. In terms of the economic benefits arising from construction, as well as from the new population being resident and adding to the population of Sileby, your judgment about the weight to be given to that element, knowing that it's been given, it's considered to be a benefit arising, but there's a difference between yourself and Mr. Gould as to how much weight you give to that.
Yes, I give that moderate weight.
Thank you. Accessibility, we know there's not an issue between us in terms of accessibility, but in terms of meeting a 5-year land supply in a location which is said to be accessible to a range of facilities and services so as to minimise the need to rely upon the private car, is that a matter of neutrality, or is that a matter upon which you give weight?
No, I give that significant weight. This is a sustainable site in a sustainable location. It has good access to shops, services, public transport, and reduces the need to use a private car.
Wrapping up the issue of ecological benefits, which you acknowledged, together with the ability to have new planting, or do they add to the planning balance?
They certainly add to the planning balance, and I afford them significant weight.
You'll forgive me dipping my toe into the waters, which were, I think, one of the few areas of dispute between Mr. Gould and I, but the issue of the nature of the existing settlement itself and the ability to soften the edge of the settlement. What's your approach?
Well, that approach at the moment is quite varying. There's lots of hedges, trees, fences, all sorts along there, and the delivery of a new high-quality, sensitively designed edge along that fringe should be afforded significant weight.
So on your approach, if the tilted balance is engaged and the benefits are added, and one looks at the harm identified from Mr. Cook's evidence, is the tilted balance outweighed? Is there significant and demonstrable harm which arises, or not outweighed?
No, it's not outweighed, no.
Is it close? Is this a marginal case?
It's not marginal in any way at all, no.
Thank you. If Mr. Higson is right, just to save my learned friend asking you the question, because it's an inevitable consequence of my doing the same, does that inevitably mean that the tilted balance is disengaged, or is that a matter of judgment for the inspector?
I think that's a matter of judgment.
And what's your view if Mr. Higson's right and Mr. Cook is wrong?
That well, I consider that the okay.
Let me ask it another way. Do you agree with Mr. Gould that the debate between Mr. Cook and Mr. Higson is determinative? In other words, that's what counts for the outcome of the appeal?
Yes, yes.
So the corollary of that is that if the tilted balance is engaged and Mr. Higson's right, does that mean the appeal is dismissed?
It's likely.
Yeah. But if Mr. Higson is wrong, does the appeal get allowed? Expecting. Thank you, Ms. Smedley. Thank you, sir. And unless there are any further points that you wish to pick up at this stage, then that's the evidence in chief.
Thank you, Mr. Tucker. No, I don't have any questions at this point. So we'll pause there. And as we indicated before lunch, I think the expectation is we'll come back to tomorrow to hear the cross-examination from Mr. Richards. So yes, I think we're obviously doing very well for time. I'm not at all concerned about how we're going to get through things in the next couple of days. I think we are, touch wood, doing very well. So thank you, Ms. Medley, for your contributions this afternoon. Obviously, we'll pick things up in the morning.
Thank you.
So before we adjourn for the day, are there any procedural points? Mr. Richards, you indicated you might have something or things to point out before we finish.
Yes, sir. Thank you. The first thing I had to point out was my microphone muting button, to click on it. Yes, you asked this morning about an update on the justification for the opens for the sports contributions.
Yes.
And we've sent you the latest document that we have that explains how those contributions are calculated. They went to the case officer at 5 to 2, according to my email on my screen. You won't have seen that because you've been concentrating on Miss Smedley.
Yeah, so I'm sure I should have that email.
Yeah.
For example, it might be a Wednesday where it happens, and therefore it might be tight.
Yeah, I'll ask later on this afternoon. I won't entertain you now. I'll find out.
Well, shall we say 2 weeks from today, unless there's a reason to extend it by a couple of days to 2 weeks on Friday? But does that sound reasonable?
Yep.
That does sound reasonable, sir. The note I just received is that sealing day for the county is Thursdays if they've received a document by the Wednesday. So that's suggested next Thursday will be the county, and then hopefully thereafterwards that should fall into my friend's client's lap. So I don't know what the sealing day is for the borough, but if that's also the Thursday, then it might be a week on Friday is sensible.
Okay. Should we just go for Friday the 13th? Not ominous date. Friday the 13th, for just to be on the safe side.
Yeah.
I think.
And just to be so that it's abundantly clear, I expect, so that what you want is a PDF copy of the of the signed copy, as it were. You don't require anything through the post.
That's correct. I'm happy with a what's it called, authorized version, or something that has been sort of signed as authentic. There's normally a sort of stamp that goes on from a solicitor or equivalent.
Yeah, certified copy, sir.
That's the word I'm looking for. Yeah, certified copy by PDF would be fine. Thank you. That's great. So unless there's anything else on the 106, we'll work to that deadline, and hopefully that's everything we need to cover. And then any from the appellant, Mr. Tucker, any update on healthcare discussion with CCG, or is that still in progress?
So we received after lunchtime, disappointingly, but matter of a few minutes ago, a letter from the CCG which identifies, let me have a look, 5 paragraphs to which there is issue taken under 2 headings, both of which I apprehend we ought to be able to respond to in writing during the course of tomorrow, sir.
Okay, and once that's done, obviously that will be circulated as part of the appeal documentation.
Yes, sir. And if I can if there's a problem with that, I'll revisit that first thing tomorrow morning. But no, Mr. Hunter, I suspect that I'll get an email late this evening.
Okay, fine. Well, we'll review that in the morning then, as needed.
Yes, sir.
Thank you for the update. Anything else from either party? Anything else from the appellant, Mr. Tucker?
Nothing else from our side, sir. Thank you.
Mr. Richards, anything else from the council?
Don't think so, sir. I'm just looking. No, nothing on the WhatsApp.
Okay, and
Thank you
any
very much.
questions or queries from any interested parties or anybody else? Mr. Tucker, you have your hand raised.
Yes, sir. Just in terms of the timing of tomorrow, given that we're going to have a comparatively short day tomorrow, I apprehend that it's the morning, unless my learned friend's estimates increase significantly. I don't know whether a 10 o'clock start will be acceptable, sir.
I was going to ask that question because I think Mr. Richards, you think you indicated an hour and a half for cross-examination. Is that still the case?
Yeah, that's about. But yeah, I won't be more than that.
Okay. On that basis, I'm happy with a slightly later start if that suits everybody else. So we can start tomorrow at 10.
Thanks.
And likewise with the final day on Friday, if starting at 10 is more convenient for closing submissions, then I'm also happy with that. But we can finalise that tomorrow.
Thank you, sir.
Thank you, sir.
Okay. Great. Well, there's nothing else from anybody. Then we'll adjourn for the day and we'll resume tomorrow at 10 o'clock.
Thank you, sir.
Thank you all. Goodbye.